Good morning. Can I welcome everyone to this, the 19th meeting of the Justice Committee in 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely, as they interfere with the broadcasting system, even when switched to silent. Apologies have been received from David McCloy and John Lamott is attending as a substitute. I also welcome Lewis Macdonald, Ian Gray, John Pentland, Elaine Murray and Claudia Beamish, who are attending today to participate in the debate on court reform SSIs, which we'll consider under item 3. I turn to item 1 in the agenda, subordinate legislation, and is to take evidence from the Cabinet Secretary on one affirmative instrument, the Draft Sexual Offences Act 2003, Notification Requirement Scotland Regulations 2013. I welcome to the meeting the Cabinet Secretary and his officials, Ian Fleming, Policy Manager, Carla McCloy-Stevens, Legal Services, and Caroline Ray, Head of Public Protection. And I would invite the Cabinet Secretary to make an opening statement on the instrument, please.
Thank you, Convener. These regulations make two substantive changes to Scotland's sex offender notification scheme. Firstly, they require homeless registered sex offenders to notify to the police certain personal information every week. This includes notifying an address or location in the UK where they can regularly be found. Currently, such offenders are only required to re-notify their information annually or if it changes. Secondly, they require registered sex offenders to notify the police of any intended travel outside the UK, regardless of the length of the trip. Currently, only foreign travel for 3 or more days must be notified. They also require notification of certain additional travel information. The regulations also make transitional provision so that the new travel notification requirements do not apply to any registered sex offender intending to travel abroad for fewer than 3 days during the 8-day period after commencement. We consider that these are necessary and proportionate measures to prevent sexual reoffending and protect the public, especially children, from sexual harm. Homeless sex offenders pose a greater risk and require a more intensive degree of monitoring of their whereabouts. The current 3-day threshold for travel notification can easily be exploited, so it is necessary to know the whereabouts of all sex offenders who travel abroad to better enable the police to manage any identified risk and prevent sexual harm overseas. Having considered the evidence, we believe the measures achieve an overall fair balance of interests, and I'm happy to answer any questions.
Any questions from members? Graham?
Please, thank you. Good morning, Cabinet Secretary, and good morning to the panel. A couple of questions. One, I note that the legislation was introduced in England and Wales in July 2012. Can you give us some insight on why it took nearly a year to introduce the same legislation here in Scotland? Well,
there's requirements that are required to go through in terms of discussions, engagement with stakeholders. Scotland's been complicated in some of these matters with elections interfering, as we've seen in previous matters. So we're catching up, you're correct there, but this is the right thing to do, and we're happy to bring them here to Parliament and would recommend them.
Are there any financial implications in trying to enforce the regime that this legislation seeks to introduce?
Not that I'm aware of. I think it's basically dealt with by stakeholders, police in particular, and MAPA obviously, who are doing it anyway. So it may increase the level of scrutiny, but I don't think it increases the financial implications for them.
Last question. Embarkation and arrivals at our airports and ports scenarios. Is there a capacity there to know that a sex offender has arrived or left the country and therefore in breach of the legislation?
A lot of these matters clearly require cooperation with UKBA, but again I think one of the strengths of Police Scotland is we now have a dedicated unit to make sure that those who operated in ports, perhaps individually through constabularies, are now doing so collectively through the National Police Service. So I think with that, with the cooperation with the UK Border Agency, and indeed with recent discussions I've had with the National Crime Agency, because there are matters ongoing there, we are satisfied that matters are as good as they can be, but clearly improvements in police IT are matters that are fundamental to this, and that is work in progress.
And you'll continue to pay additional attention to that work in progress to make sure it delivers?
Oh, I can give you absolute assurance on that.
Thank you.
Sandra White.
Very much, Convener. It was a similar vein I was going to ask from Graham Pearson. First of all, I really welcome this piece of legislation, as we know that trafficking on the increase in certain countries anyway, and I think it's a good piece of legislation. But to follow on what Graham Pearson was saying in regard to monitoring, will we be looking at monitoring this legislation within a year or 6 months? Is there a timescale on that to see how it's actually working?
Well, to some extent, the monitoring is already done through MAPA, so the framework is there. This just increases their powers and the level of scrutiny. So I don't anticipate any delay other than the necessary progress for the information to be out there and advice to be provided. Because, as I say, the framework exists. This is about an enhancement of their powers, greater scrutiny and greater requirements upon the person who is the registered sex offender.
Jenny?
Thank you, Convener. Cabinet Secretary, there have been incidents in our communities over the last few years of sex offenders from other jurisdictions coming to Scotland and offending in Scotland. Has the Scottish Government made any progress on relationships with other governments to get that information so that these things can be prevented?
Well, yes, we do. We do it at a variety of levels. Obviously, one of the first ways is through Europol and matters there. Some of this is about making sure that other jurisdictions, some perhaps in Central or Eastern Europe, where the information they collect is not as good and the information that they retain, sadly, is not necessarily as accessible. Equally, in matters closer to where you are, we've had difficulties with the Irish Republic. These are matters that have been on the agenda at the trilaterals that I have with the Justice Secretary for the Republic of Ireland and indeed with Northern Ireland. There is work in progress there. Much of that actually is not so much what we require to do here, but how we create the relationship and equally how we can try and get best practice there. So at all levels, at police, at Europol level, working through the United Kingdom, because some of these matters do require to be dealt with by the Home Secretary in terms of international relations, but closer at home, clearly in our relationship with the Irish Republic and Northern Ireland. We work very closely and are seeking to make sure that we appropriately engage, again, all levels, whether it's at social work, engagement with police officers, and indeed, again, as a point I think is made by Graham Pearson, ultimately improving our own ICT system, but sometimes making sure that these things are linked in together.
I mean, I've allowed that question, though it's not directly related to the SSI, so if you wish to proceed on that, I'm content, but it's really not.
Well, I think it's work in progress. We recognise the challenges because tragedies have befallen, and equally, although people have come from other jurisdictions and perpetrated offences here, as I think Sandra White was alluding to, we also know that sadly people from Scotland seek to go from Scotland to perpetrate offences elsewhere. This is a two-way street. We require to work with other jurisdictions. Some are not as advanced as we are, whatever challenges we may face. We have to try and support them. We do that through Europol. We interact through the National Crime Agency, through the Home Secretary. Equally closer to home, given the proximity to Ireland and our Celtic cousins, there are matters that we have to do there, both in terms of ours who travel there, as we have had high-profile Scots who have gone there, and indeed those who come here, and we've had the tragedy and devastating matter in Dundee.
Baptist, are there any more questions on the SSI? There are no further questions on the SSI, therefore move on to item 2, which is formal debate on the motion to approve the instrument considered under the previous item. Can I invite the Cabinet Secretary to move S4M 06873 in the Draft Sexual Offences Act 2003 Notification Requirements Scotland Regulations 2013.
Moved.
Any members wish to speak in the debate? No members wish to speak. So I'll put the question. The question is that motion S4M 06873 be agreed to. Are we all agreed?
Yes.
We are agreed. Thank you. We are required to report on all affirmative instruments. Are members content to delegate authority to me to sign off this report?
Yes.
Thank you very much. And the Cabinet Secretary is seeing the next item. I thank his officials for attending. I suspend the meeting briefly to allow them to swap over. Our next item, item 3, is a debate on 2 motions to annul the following negative instruments: Sheriff Courts Districts Amendment Order 2013, SSI 2013/152, and Justice of the Peace Court Scotland Amendment Order 2013, SSI 2013/153. I propose to take both motions together, and so standing orders allow the debate to last for up to 3 hours. I'll call Lewis MacDonald first as a member proposing the motions to speak to and move both motions. I'll then move to open debate when I'll call members in turn. Once the speakers list has been exhausted, I'll invite the Cabinet Secretary to respond to the debate. I'll then invite Lewis MacDonald to wind up. And of course, we have room for interventions if members wish, and it's up to the member whether or not they take it. At the conclusion of the debate, a separate question will be put on each motion. If the motions are agreed to, the SSIs will be debated further in the Chamber. If the motions are not agreed to, that will conclude parliamentary consideration of the issue. Everybody happy? Well, maybe not happy, but we understand where we are. All right. I'll now call on Lewis MacDonald to speak to and move motions S4M 06648 and S4M 06649, that the Justice Committee recommends that the Sheriff Court District Amendments Order 2013, SSI 2013/152, and the Justice of the Peace Court Scotland Amendment Order 2013, SSI 2013/153 be annulled. I can allow you, Lewis, around 15 minutes.
Thank you very much, Convener. And as you have said, these motions seek to annul the Government's orders for the closure of Sheriff Courts and JP Courts in a number of towns across Scotland. They currently have the support of 3 of the 4 parties represented on the committee, and of many of those who have made representations to the committee in recent weeks, or who responded to the earlier consultation by the Scottish Court Service. I hope these motions will also attract support from other members of the committee today, because only then will there be further debate and scrutiny of the Government's proposals. A majority of votes today against annulment of the statutory instruments will be final decisions that those courts will close. Those are very serious and substantial decisions. I do, of course, recognise that for Government supporters to vote against what the Government wants is also a serious matter. But members of any Parliament have to be willing and able to assert their independence of any government when they believe the government is getting it wrong and that the issue is important enough to take a stand. On the merits of the issue, a clear majority of members of the committee are on record in recent months in opposing at least some of the proposed closures. Some, of course, may have changed their mind, but given the stated view of so many members of the committee, it is disappointing that the government itself has not taken a more measured approach. When Parliament debated these proposals back in April, I called on ministers to bring forward individual orders for individual closures. That would have allowed members of all parties to pass judgment on particular proposals rather than voting either for or against all of them at once. It is the Government's choice to package all these proposals together, and by doing so, it has put its own supporters in as difficult a place as possible. I don't believe that Government has to pursue such a take it or leave it approach. A different government in the first 8 years of devolution took a different approach. Savings had to be made then too. There was an argument from Government that buildings should close where their running costs were seen as out of proportion to their contribution to local access to justice. The closure proposals then were relatively modest. More importantly, as members here will recall, the Government of the day was open to persuasion and open to compromise. So money was indeed saved, for example, in Peebles and Rothsay by giving up dedicated standalone court buildings and ensuring local access to justice through partnership with local authorities. That meant courts sitting only a few days a year, in line with their volume of business. It also meant much reduced overheads. It was a win-win compromise, which could have provided a very good model for a distributed system of justice, which the present government might have chosen to follow. Instead, local courts meeting infrequently in other people's premises have been seen in the current process not as a cheap and convenient way of maintaining local access to justice, but as a burden of avoidable expenditure and an obstacle to rationalisation of the system as a whole. So they were the first target. Courts sitting for fewer than 3 days a week, unless they were remote from centres of population, were defined as a problem and not as a solution. The Sheriff Courts at Dingwall and Stonehaven, Arbroath and Cooper and Haddington would of course have survived that test, but they were put up for closure because they were within 20 miles of another Sheriff Court. What is most disappointing about the Government's approach is not just the scale of the closures proposed or the impact of individual proposals. It is the apparent lack of imagination, the unwillingness to seek compromise and the single-minded pursuit of cuts and closures. Of course.
Through the chair, but it doesn't matter. You just
My apologies.
Right. No, it's all right. Cabinet Secretary.
Could you detail the courts you think should close?
Well, what I would suggest to Mr MacAskill is that he should consult with local opinion. And I'll come to some of the court closures which local opinion has broadly endorsed in just a moment. What I worry about is that Mr MacAskill will no doubt tell us later about the cuts and closures of courts elsewhere by the UK Government of Westminster, as he indeed did last week. The problem with that approach is not just that it seeks to avoid debating the issues for which his government is accountable. It also fails to acknowledge how the devolution of powers to a Scottish Government and a Scottish Parliament can be made to work. The point of bringing government closer to the people is surely to create a genuine dialogue between those governing and those governed, where decision makers and campaigners can listen to each other and act on what they hear. Compromise on court closures a decade ago was the right outcome at the time. It was also the kind of outcome which devolution should always be capable of achieving. At the beginning of this parliamentary session, Alex Salmond said that his majority government would act like a minority government. There is no sign in this debate, certainly not yet, that the government has been prepared to listen, even when the criticism has come from their own parliamentary colleagues. Had they done so, we might have a very different debate today, as Mr MacAskill's question actually implies. Instead of a raft of court closures and the implicit threat of more to come, we might instead be considering a smaller and more rational set of proposals commanding much wider support. If Peebles and Rothsay could continue a decade ago by decanting from one building into another, something similar could surely have been done here. If Scottish Borders Council and Argyll and Bute Council could find ways to support local justice 10 years ago, perhaps they should have been given the opportunity to do so again today. East Lothian Council has already offered support for local justice, taking on the running costs of Haddington Sheriff Court, offering to share the backlog of maintenance costs which were built up by the court service while it was spending tens of millions in Parliament House. That seems a pretty good model of the spirit of compromise, of devolution and of shared interests and partnership in the Scottish public sector. Stonehaven Sheriff Court already takes cases which would otherwise add to the already chronic delays at Aberdeen, dealing with cases local to the Kincardineshire area, but also acting as an overflow for a busy city court. There is plenty of feeling in the town against closing Stonehaven Sheriff Court. An imaginative compromise might have been to attach Stonehaven to Aberdeen, to use its existing facilities to improve the working of the justice system, rather than closing the court at Stonehaven and then having to acquire extra premises in Aberdeen. But such a compromise, as we heard last week, was never even sought. Highland Council, like other local authorities, took a balanced and constructive approach to the proposed changes. They concluded, Mr MacAskill will be delighted to hear, that the closure of the JP courts in Wick and Portree would not have a significant impact upon access to justice. They published a considered and pragmatic analysis of the relative function and utility of the court buildings at Dornoch and Tain. They argued to retain jury business not in those courts, but at Wick. They concluded, on the other hand, that the closure of Dingwall Sheriff Court would have a detrimental impact upon access to justice, and expressed concern that the High Court would cease to hear cases in the Highlands. Neither simple acceptance of whatever central government proposed, nor a dogmatic opposition to any cuts or closures, simply an honest attempt by that council to assess how best to protect access to justice in their area, a rational alternative to centralisation, and a basis for compromise if compromise was wanted. But sadly, in Mr MacAskill's pursuit of a centralised and streamlined justice system, compromise has not yet been part of the agenda. Of course, there have been court closures before. Nobody would suggest that there should be no court closures in future. Members need not disagree with all the proposals in these orders in order to conclude that they should send them back. Annulment is the right thing to do if members believe that even one of these proposals needs to be thought about again. And the evidence given to this committee in the last few weeks has suggested that this is no ordinary round of closures. Lord Gill said last week if we were to sit down today and plan a justice system for Scotland, it would be nothing like the present pattern, which is based on a Victorian model. And he predicted that there will be much greater use of remote access to the courts as the years go by. I believe that the current proposals have to be seen in that context. They are substantial in themselves, but they also point the way towards a very different means of delivering justice in future. The Court Service Chief Executive, Eric McQueen, made that very clear when he gave evidence last month. We are trying, he said, to look at how we can best deliver justice in the borders by having one central hub, which will be the main place where we deliver that business, before going on to reveal that similar exercises were also already underway in 3 other regions of the country. It would be naive to doubt that those things are closely related. If the starting point of these proposals is that our court system is Victorian and should largely be replaced by virtual justice delivered by remote access to a much reduced number of courts, then clearly a vote today in support of the government's proposals is more than just a vote to close these particular courts. It is also voting to accept a future direction of travel which will see yet more local courts put out of business in the future on the basis that the idea of local courts is itself out of date.
Did the member take an intervention?
Of course.
I'd like to have a
indeed.
little talk. Just, I earned my keep. Right. John.
Thank you. I wonder would the member accept that one interpretation of the words he's just passed in relation to video conferencing is that that's some sort of second-rate form of justice, but for many it's pivotal to them coming forward and acting as complainers.
It is not a second-rate form of justice. It's certainly, as Mr Finney correctly says, essential in the case of many vulnerable witnesses. But I think anyone who has engaged with the court service, and there are many around this table who have done so, will recognise that video conferencing is not a substitute for appearance in person, either from the point of view of the accused obtaining justice or from the point of view of those who wish to cross-examine witnesses on the basis of the evidence they have given, or from the point of view of local communities who want to see justice done in their midst. And if Lord Gill described Scotland's Sheriff Courts as Victorian, Kenny MacAskill last week went much further. He compared the continued existence of Haddington Sheriff Court with a range of statutes that have had to change from statutes on capital punishment down to statutes on the stocks. Well, the choice of analogies is revealing. The death penalty was abolished in the 1960s because its use had come to be seen as no longer defensible in a civilised society. The stocks ceased to be used in the 1800s for similar reasons. So is it therefore that a system of justice based on appearance in person at the local court seen as outmoded and no longer necessary in a high-tech society? Because if the Scottish Court Service does indeed reduce courts provision in the borders to a single main centre, we must conclude that either Jedburgh or Selkirk will not survive. There will in any case be no jury trials held anywhere to the south and east of Edinburgh. With feasibility studies underway in areas like the Highlands and Fife, the future of courts in those areas may also be called into question. Dingwall and Dornoch today, perhaps Wick or Tain tomorrow, there are already planned to be no jury trials in mainland Scotland north of Inverness. Cooper is to close, Kirkcaldy is to lose jury trials. Perhaps a single justice centre is all that will be left in Fife in a few years' time. Some might say that the writing for courts in these areas is already on the wall. And no doubt there will be other feasibility studies to come, and it is at least predictable that other local courts with relatively low volumes of business will face the threat of closure. Yes, there will be 16 courts in the Premier League, not only dealing with jury trials in future, but also dealing with the centralisation of what the court service calls the civil, administrative and miscellaneous jurisdiction of the sheriff. But what else will survive a further round of court centralisation is an open question, and it is a question, I believe, that members should consider carefully before casting their votes today. I urge members to vote for annulment of these orders in order to allow government to pause and reconsider that direction of travel, and to allow Parliament as a whole to take the final view on the closure proposals before us today. And I move the two motions in my name.
Thank you very much, Lewis, and you've done it well within time. I've got Alison McInnes, then John Lamont, then Graham Pearson.
Thank you. Thank you very much, Convener. And I have signed the motion to annul, and I speak in support of the annulment today. There are many reasons that have been presented to us to protect the courts: civic pride, community cohesion, economic impact, the impact, the disproportionate impact on different equalities groups. And on that point, I would say the equalities impact assessment has been pretty sadly lacking. But at the heart of all of the arguments really is the value that we place on access to justice and local justice. Our courts are robust institutions that have an impact in our local communities. And these proposals that are being put forward by the government today will have a significant impact on people living in rural Scotland in particular. Liberal Democrats believe that dispensing of justice should be as local as possible. I believe there are real...
Mention through the chair.
Thank you very much, Cabinet Secretary. Will you?
Yes.
Yes,
Yeah.
thank you.
Can I just ask the member why it is that it appears to be acceptable to the Liberal Democrats to close 93 out of 330 magistrates' courts in England and Wales and 49 county courts, and yet it's entirely unacceptable to consider any closures north of the border?
I think that's a question you must ask my colleagues in England and Wales. As Lewis Macdonald rightly said, this is a devolved parliament taking decisions about Scotland, and we have a very particular view of how we think that should be done here, and we are perfectly at liberty to make that case. I think there are real dangers in delivering justice remotely, and as Lewis Macdonald has pointed out, that's where we're heading. We're heading towards dispensing justice remotely. There are very significant concerns about the disproportionate impact that there will be on children, young people and women from these proposals. The Association of the Directors of Social Workers have pointed that out. Scotland's Commissioner for Children and Young People has warned that there may be a detrimental effect on children. There have been little regard, I think, in the proposals for the impact on family law in particular. Women's groups have warned that vulnerable witnesses will be exposed to greater risk. We've heard from the Sheriff's Association, from the Law Society, from very, very many people around the country that they are concerned about these closures. I don't doubt that it's administratively convenient for the court service to do this, and there might well even be some savings. I'd like to just make some progress.
In a moment.
There might be some savings, but the evidence that we've heard points to these savings being made only by passing them on to other partners in the justice system. I think communities around Scotland are rightly outraged at this latest attack on the services available in our towns and in our villages. And this centralisation drive really needs to be halted. If we turn to the particular cases of the courts within my own region in the northeast of Scotland, there are two courts proposed for closure on the kind of proximity basis. Stonehaven closed and business moved to Aberdeen Court, where it's already overstretched. And as we've heard already, Stonehaven currently acts as a safety valve. It doesn't make sense, it's not coherent to propose that. In Arbroath, the proposal is to close Arbroath and move to the business to Forfar. There is an economic impact there. Their public transport links are much poorer, and the support for vulnerable witnesses, we've heard, are much better in Arbroath than they are in Forfar. These proposals seem to me one-dimensional proposals. They don't take account of what else is happening in court reform. The civil court reform proposals are going to push more business into the Sheriff Court and, again, create greater pressure. So,
well, I've got, which one do you want? Sandra, and I've got Roddy. Well, oh, right,
sorry,
Roddy. So, she is within hitting distance, you know, Roddy.
The member accept that, although it's perhaps unfortunate that the Court Reforms Bill consultation is only recently closed, that we have had assurances from the Scottish Court Services in relation to the impact of the transfer of cases from the Court of Session to the Sheriff Court. Does she not accept those assurances?
I haven't been able to properly interrogate them. The consultation has just closed, and I think it would have been much more coherent to take these two things together and consider them in the round. I'd really urge the committee to follow the evidence. We've heard overwhelming evidence on this matter from both written evidence and evidence given in public to us. We should follow that evidence. Apart from the court service and the government, no one is saying this is a good idea. The committee needs to work together, pay heed to the concerns, however inconvenient it is for your government.
You want Sandra White would like to have another chance.
Sandra.
Thank you very much, Alison. I'm a wee bit concerned when you mentioned the fact about families, children, women's groups, etc. This would be detrimental to them. We heard evidence from Victim Support Scotland, which was very much supportive of video conferencing. We also have heard evidence regarding children's hearings, which I think is very important, particularly in the Dundee area, being conducted in SCRA offices. And that was the evidence that we received from witnesses said this was a good way forward. We also heard from Cabinet Secretary and others that they were looking to put this out to other areas as well. Would you not think that that is a good thing? Because obviously if you have vulnerable witnesses such as children, women, etc., they welcome the fact that they don't have to go to court to give evidence. I'm just asking.
Intervention, so you get extra time.
I waited a long time for it.
Right.
Well, all the way through this, we've heard from both the Court Service and from the Cabinet Secretary that video conferencing is the solution to everything. I'm very, very concerned about that. Yes, it has its place to play and a role to play, but it will not solve the problem of access to justice locally. So I do urge the committee, I was just winding up, I urge the committee to act in the interests of the people of Scotland, of our communities around Scotland, and at least have the courtesy to send this to the full chamber for it to be properly debated there and for everyone to be able to speak and indeed vote on the matter.
Thank you very much, Alison. John Lamont, followed by Graham Pearson.
Thank you, Convener, and I'm also happy to be speaking in support of the motions to annul this morning. Today this committee has the opportunity to send a message to the Scottish Government that plans to close a fifth of Scotland's sheriff courts need a rethink. I doubt even this SNP government would have the brass neck to close a fifth of our schools or a fifth of our hospitals, so vocal would the outcry be. However, the Scottish Government seems to believe that our justice system is fair game for savage cuts. The Justice Committee does have the opportunity today to send the message that court users, victims and witnesses of crime and our small towns are worth standing up for. The Government has sought to downplay the impact of these proposals, stating that they will affect only 5% of cases. However, this 5% represents a substantial 12,500 criminal and civil cases. Despite not being the busiest of courts, Duns in my constituency hears over 330 sheriff cases a year, with the JP court sitting fortnightly. Take an intervention.
You want to take it, John, right?
I just wondered, given that Mr Lamont was delighted to welcome David Cameron, the Prime Minister, to the Tory conference and support the Better Together in Union, what did he say to him about the 93 magistrates' courts and 49 county courts being closed across England and Wales? Did he have any comment?
Well, the Prime Minister is responsible for the UK Government. You are responsible Cabinet Secretary for the Scottish justice system, and I'd be grateful if you could focus on that rather than worrying about what's happening south of the border. I'm in no doubt that the Duns Court is a local service which is worth fighting for. A further tactic of the Government, and indeed many SNP backbenchers, has been to blame the Westminster cuts. But if they actually look at the facts, the reality is the Scottish Government's budget for 2012-13 has seen a cash terms increase of £250 million. Rather than protecting our courts, the Scottish Government has instead decided to decimate the SES capital budget, which will fall by a staggering 80% by 2015. Let us be in no doubt, it is because of the decisions taken by the Scottish Government that the court service is having to propose ill-advised savings.
Colin would like to intervene.
I just want to make some more progress, if I may, Mr. Chair.
Thank you.
The Government even claims that these plans will result in a broadly neutral economic impact, despite all the evidence this committee has heard to the contrary. The closure of so many courts will harm access to justice, they will pass on costs to victims and witnesses, will result in increased delays and therefore increased costs, they will divert cases to some of Scotland's busiest and least efficient city courts, and they will result in the loss of significant business and footfall away from regional towns across Scotland. And these proposals come at a time when the Scottish Government is planning on diverting significant civil business away from the Court of Session to our sheriff courts. These closures make no sense nationally, but they make even less sense for rural communities like those in the borders. I make no apology for mentioning my constituency because that's where my priority lies. The closure of Duns Sheriff Court will force victims and witnesses to travel over 30 miles to Jedburgh Sheriff Court. Indeed, the court service has conceded that the closure will result in some of my constituents being unable to travel to Jedburgh by public transport without an overnight stay. This breaches the court service's own principles for provision of access to justice. And during our inquiry, we also heard the bombshell that proposals for justice centres will result in further court closures within a relatively short period of time. Exactly what these justice centres will involve and what areas they will cover remains unclear. However, looking at the list of sheriff courts not pencilled in for closure, I can guess that a further 10 may be at risk, and the borders may be left with only one. These plans are yet further evidence of the SNP's increasingly metropolitan outlook and centralising tendency. They will result in diverting more and more public services into the central belt and major cities, ignoring the importance of local services and local access to justice in areas such as the borders. Indeed, as the committee heard from Stuart Naismith of the Law Society of Scotland, if we take justice centres to their logical conclusion, we would have just one centre, ignoring the inconvenience to court users and loss of local justice as a result. But at what point, Convener, in the drift towards greater and greater centralisation, will SNP backbenchers have the courage to say enough is enough? The committee has also heard sensible alternatives which would make savings but maintain a court in Duns from Sheriff Drummond. Indeed, alternatives exist across Scotland, including moving courts to a part-time basis and the better use of existing public buildings. And in my constituency, to add insult to injury, the closure of Duns will make only relatively minor savings. We have heard clear evidence against these court closures, but the question which remains unanswered today is, will the SNP members on this committee blindly follow the voting instructions they no doubt received this morning, or will they think for themselves? These plans need a full parliamentary debate, and the committee should allow this to happen. Now, I make no apology for mentioning a few names. Most likely because Colin Keir does not have a court in his constituency, he has been the least vocal in his criticism. I do not hold out much hope for him voting against the court closures today. Sandra White, who also does not have a court in her constituency, at least promised robust and thorough scrutiny, and the evidence received by this committee will surely suggest that Sandra will vote against these proposals. John Finney, no longer an SNP member and therefore able to vote against a government when he believes this is the right thing to do, abstained on the Scottish Labour Party debate on justice in April. He clearly had concerns then, and I fail to see how anything we have heard since could dispel these concerns. We know that other SNP members on this committee have strong reservations about these plans. There is no shortage of evidence of comments in their local press. Roderick Campbell has admitted the proposals for Fife are severe, and it is clear to me that retention of Cooper Sheriff and JP courts is by far the best course of action. The convener promised her constituents via a BBC interview in April that she will continue to oppose the closure of Peebles Sheriff Court. Let us be clear, by voting in favour of court closures today, committee members will be saying that they know better than the 95% of respondents who rejected these plans, and they support the Scottish Government's decision to cut the court services capital budget by 80%. Roderick Campbell and the convener have a clear choice today. Will they defy their party and stand up for their constituents? Will they protect the SNP government from a fully democratic parliamentary debate? Will they blindly follow voting instructions or back up their words with action? Or will they put their party interests first, local people second? Thank you.
I don't know if I'm thanking you for that, but there we'll move on to Graham Pearson, followed by Ian Gray. Thank you.
Thank you, convener. I don't know that in the last 2 years on this committee that I've received so much correspondence in connection with one issue. As of this morning, coming into the chamber, I'd received 200 emails from interested parties across Scotland who raised serious concerns about the proposals contained in this amendment orders. Letters have been fulsome in the evidence that they have provided, which should cause the Cabinet Secretary to think twice about the provisions that he's laid out before us, not to mention the petitions that we've received beforehand. One of the major concerns for me lies in the context of the impact on witnesses and victims. In light of the new legislation that the Cabinet Secretary leads on, in providing support for witnesses and victims, and in the context of legal aid changes that are happening elsewhere within our system, it's hard to believe that the provisions that are contained in these amendment orders will go any way to relaxing the stress, the anxiety that would be felt by witnesses and victims as they have to travel substantial distances by public transport in many cases at their cost initially. Many of the victims and many of the witnesses who attend our courts come from the most vulnerable sections of our communities across Scotland. The easier that we can make their lives in accessing justice, I think, reflects a more inclusive society and one that tries to deliver not only in justice in the broadest sense, but also in social justice. The time that witnesses spend in repairing to courts so that they can prepare to give their evidence on behalf of the state at the end of the day, not solely in connection with their interests at the court, should be important to us all. And therefore, the notion that access to justice can be provided by encouraging witnesses and victims to travel even further than they currently do seems counterintuitive. Throughout my time as an adult, I've always understood that justice done is justice that's seen to be done. In the light that courts are being removed from the very hearts of many of our communities, and across the south of Scotland, that means Duns, Haddington, Peebles, and as far as the JP's court at Annan, it's removing justice from the heart of these communities. And that cannot be the delivery of a premium service in a modern 21st century Scotland. We've heard much in this committee over the last month about churn, and it became part of the currency of some of our witnesses that they talked about the churn of costs. That's the churn of costs from court service budgets to other partner agencies' budgets. And there was a concern from local authorities about the impact on social workers and other professionals who would be required to travel out with the authority areas to courts nearby, or even within the authority areas, but across fairly significant distances. Added to that, the impact of removal of courts from within communities. There's no doubt that in the towns of Duns, Haddington and Peebles, these courts have a significance for the towns. They are a fulcrum around which the towns operate, and there is a concern expressed by the voters and the public in these areas that the removal of the courts remove part of the character, part of the raison d'etre for these communities to exist. Not to mention, as was shared with this committee, the notion of Shrivel knowledge and that local intelligence that exists about the difficulties and the problems that these communities face. Convener, I'd be happy to.
John?
Thank you. I'm grateful for the member taking intervention. Would the member accept that Shrivel knowledge extends beyond geography into the specialisms, and that's one of the challenges faced, the various range of specialisms that are being developed across the Shrivel experience?
I do accept that there is a need to develop specialisms in some developing areas of criminality and civil law also. But equally, within communities, the knowledge that local courts truly understand these communities, truly reflect these communities' concerns are significant, and means that justice has a relevance for these communities, has a true meaning in the way it impacts on some, one would think externally, fairly minor matters, but ones that are significant and important to local communities as they impact on them week in and week out. Shared also with us at this committee in terms of Haddington were the Chief Executive and the leader of the council, who explained that Haddington Sheriff Court was a shared facility, one that local authority invested in and were equal in their management of that facility on behalf of the town. As I understand it from the local authority, they've made an offer to pay some of the costs that the court service deemed as on costs for the management of Haddington Sheriff Court at that location. And it's their view, as expressed to me during a time that I spent to them, that they felt that that consultation process took little or no heed of that offer, and that there was no consultation thereafter to look at the impact and suggest how that might affect the future of Haddington Court. Equally, as far as Peebles was concerned, Borders local authority indicated that they felt that their voice had not been heard, that no discussion, no meaningful discussion had taken place, which would have given them some comfort that they'd misunderstood the circumstance. I'm happy, Convener.
Thank you. I just wanted to ask the member, we were talking about consultation. Last week at Lord Gill's evidence, I think you asked much the same question of Lord Gill about consultation, and his answer was it was the most extensive consultation he has undertaken. Would you agree with that then, from Lord Gill?
I would never deem to question Lord Gill's assessment of his experience of that process. But the truth of the matter, equally coming from the Chief Executive, Leader of the Council and from other councils, is that their experience of that consultation process was less than meaningful from their perspective. And there's no doubt that if you look at it internally from the court's perspective outwards, it may well have felt meaningful for them, but from the community's view, looking into the court service as one of many services that they experienced within the community, they didn't feel that their voice had been appropriately heard. And I can only reflect the honest assessment that they gave to me during the time that I spoke to them. And equally, we had the novel suggestion from Kevin Drummond, Sheriff Kevin Drummond, who seemed to indicate that travelling justice was a meaningful opportunity for the future, and that could be delivered across, in his view, the borders area with some effect and some impact. And one doesn't see any reflection of these concerns and these options within the documents that were produced to us here at this committee. So the absence of a meaningful consultation, the notion that evidence from the lawyers, from the Law Society, from communities, from local authorities, and from those who presented themselves here at this committee, the fact that so many people felt a discomfort in the way in which their views had been weighed and had been offered for the future in deciding these proposals leaves me in some doubt that proper consultation has occurred and that proper decisions have been taken about the way forward for the future. Insofar as the use of closed-circuit television and all the other new technologies that might be available to us, again, I believe that justice done is justice that needs to be seen to be done within communities. And there was always a principle that applied that best evidence was what we sought within our Scottish courts. There is no doubt circumstances where witnesses' evidence and victims' evidence can be best received through closed-circuit television provision. But to expect that all court cases might benefit from the use of CCTV at this stage in our development, I think is a step too far. As a
Graham, can I just alert you to you've had about 8 minutes.
I'm ready to finish.
I'm on my last sentence. A lot of stuff.
I'm on my last sentence.
Okay.
As the Cabinet Secretary listens today to the debate, it would be of some comfort for us to see that he was not only willing to listen, but he is also willing to amend his proposals. And I hope that this committee, in rejecting the amendment orders, can take the first step to reconsidering the options available to us. Thanks very much, Convener.
That's all right, Graham. Thank you. I've got Ian Gray. I'm going to take now Ian because it leads on from the Haddington stuff. And then I'll take Colin Keir, who's coming in with, I think, probably a different argument. And then I've got Jenny, and then I've got Elaine, and then Claudia. OK, you are there.
Thank
Ian.
you. Thank you, Convener. I speak specifically with regard to Haddington courts this morning, though I'm sure many of the arguments I want to make will apply to some of the other courts affected by these orders, particularly those courts in county towns where the decision is based entirely on the proximity to another court. The orders before the committee today would close both Haddington Sheriff Court and the JP Court in the town. Now, it may well be true that some of the courts referred to in the orders carry out relatively little business, but that is not the case with Haddington, which is a busy full-time court. Indeed, with regard to the courts listed in the orders, Haddington has had in recent years by far the highest number of civil cases and one of the highest numbers of criminal cases raised. Last year, over 2,750 criminal summary complaints were raised, and many procedures are increasing. For example, adults with incapacity applications have risen by 70%. Around 3,500 what the court service calls civilians use Haddington Court each year, and East Lothian has the fastest growing population of any local authority in Scotland, so this can only be expected to increase. The Cabinet Secretary has often, in the course of this debate, referred to a modern one-stop shop model of local justice, as in Livingston. But in Haddington, court, police, fiscal service, CAB advice services and social work may not all be in one building, but they are within 20 yards of each other in the centre of the town. And as a result, justice is not only administered efficiently and locally, but is very much seen to be administered locally. For within those 20 yards, we also find the local newspaper, which reports court proceedings assiduously, and our local sheriff has made clear that he believes that some of the deterrence of an appearance in front of him lies in the certainty of exposure in the local press. Now, all of this will be lost if the committee do not annul these orders today. Court users will spend many hours travelling to Edinburgh. Multi-agency working will become difficult to schedule. Local law firms may close or withdraw from court work. Police officers will spend time in Edinburgh rather than East Lothian. Social workers' caseloads will become even more unmanageable. And local JPs have made clear that many of them will simply retire, unwilling to sit in Edinburgh. But above all, innocent victims, witnesses, and families coping with debt or family breakdown will face drawn-out proceedings in a busy and more intimidating city court. Apart from the human cost, East Lothian Council have calculated the loss to the local economy in the town as over £360,000 per year. But even if all of this is set aside, this proposal makes no sense. Ministers set targets for court. The target is the percentage of cases disposed within 20 weeks, and their target is 85%. Haddington, in the last figures available, was very close to that target, 83.8%. Edinburgh achieved only 58.4%. It is clear that Edinburgh cannot meet ministers' own performance standards, even without the additional burden of East Lothian work. And if this is simply a cost-saving measure, then at best there is a marginal benefit. The court service claims that they will make a saving of around £81,000 a year in running costs, but £34,000 of that is depreciation, a paper saving. The only real benefit is of the order of £47,000. But the truth is that this cost and more will be pushed onto other public sector budgets. It has been estimated, for example, by a forensic accountant that some £85,000 a year additional cost will be the cost for non-legal public sector workers as a result of going to Edinburgh instead of Haddington. And when it comes to capital costs, as Lewis MacDonald has already indicated, the Council has made clear that it would accept responsibility for more than half of the around £500,000 backlog maintenance the court service says is necessary, and they have offered to share ongoing costs rather than see our court close. So in the case of Haddington, at least, this is a measure without a rationale and without a purpose. It is neither efficient nor will it save money. It is damaging, it is inefficient, and in the long run, it is potentially costly for the public purse. In the face of powerful evidence and widespread local opposition, and I say to Sandra White, this may have been an extensive consultation. It raised not one single submission in support of the closure of Haddington Court, and many opposed to it. This has become simply an exercise in obstinacy. Lewis MacDonald has already said, and it's true, that the committee faces a serious and substantial decision this morning, a historic one too. There has been local justice dispensed in Haddington since the 12th century, one way or another, and I agree with the Cabinet Secretary, it has changed over time, but it has always been there. And there has certainly been a Sheriff Court there for some 500 years. It survived 300 years without a parliament in Scotland. How ironic would it be if we use our own recently achieved democratic accountability to get rid of that tradition and the principles of justice delivered locally, accessibly, publicly, and by our peers, if we used our democratic autonomy now to consign that to the dustbin of history. Before committee members do that, I would ask them simply to stay the Cabinet Secretary's hand by annulling the order this morning and at least allowing a further reconsideration by the whole of this Parliament on this important decision.
Thank you very much, Ian. I've got Colin Keir now, please. Colin.
Thanks, Convener. There's absolutely no doubt that these courts in local communities that are earmarked in this report for closure bring out an awful lot of very strong feelings from various members and some members of the local community. And it's easy enough to sort of look at these and take them on board. They're totally understandable, some of the feelings, the historical aspect that Ian Gray has mentioned is absolutely true. However, I can't help but feel that having listened to the Lord President last week, and along with Eric McQueen, and what they produced was a robust set of statements which supported the idea of these reforms being put through. We do have a longer term issue in terms of sustainability, and this is where I did obviously try to intervene with Mr. Lamont, and there may well be a cash terms increase in Scottish block grant. However, if we aren't in a period of austerity, why is the Prime Minister and the Chancellor telling us we are in it, and why are we in such a financial mess? Which makes me suggest that there's an awful lot more to the statement you really should be taking into consideration. There are cost issues involved here. And we do have a choice. The Cabinet Secretary has been, shall we say, chastised for bringing in the likes of the 93 magistrates' courts that are being shut in England. But the choice is very clear. We either try and keep a service, one which is compatible, sustainable, and true to the values of the Scottish legal service, or we go down the road south of the border, which the Conservative Liberal coalition is seeking to almost dismantle in terms of what they're actually proving that they're doing. Of course, I'm quite happy to take an intervention.
You're offering us a false choice there. What's quite clear is the government has a budget, and the government makes choices with that budget. It's not either close all the courts like they're doing in England, or be sensible, as you seem to be suggesting. There are lots and lots of options, and I'll remind members that on the day that Lewis Macdonald led the debate in the Chamber, the Transport Minister announced a £4.6 million fund that he had suddenly discovered to give to Scotland's canals for their Living on Water initiative. That was a choice they made. They could have made a different choice with that.
Well, that may well be true. However, what I would suggest to you is the fact that we're looking at this moment at a sustainable legal service for Scotland. And these views were put forward by the Lord President, and I noticed in the interrogation, shall we call it, last week, I wouldn't exactly say that a hell of a lot of firepower, if you pardon my French, was aimed at the Lord President. So understandable the feelings that it brings through, but I think there has to be an acceptance that reform and sustainable reform is required. Now, I agree with some of the comments that Sandra White made earlier on in one of her interventions. Some of the reform groups which dealt with vulnerable children and the likes, they're welcoming these reforms. We also can't forget in certain circumstances that the state of some of the courts that we have, we've been critical. Those of us who sat around the round table listening to the vulnerable people who came and gave us their experience of some of the courts that are in our society that are simply not up to the case. So these justice centres have a possibility, real possibilities of providing long-term security in that way as well. I do understand, as I say, the feelings that are pent up, but we do, I believe, have to support Lord Gill with his reform programme. I make no apology for that. I understand where the opposition is in this. I will not accept the denial that there is no period of austerity. I think Mr Lamont's way off the mark in that. And I will be supporting the the government's proposals. I certainly won't be supporting what's on the table here. Thank you.
Thank you, Colin. I have Jenny Mara, followed by Elaine Murray. Jenny.
Thank you, Convener. I want to begin by focusing my remarks on the closure of Arbroath Sheriff Court and Cooper Sheriff Court and the resultant transfer of business to Dundee Sheriff Court. The impact to Dundee of the Scottish Court Service plans that the Cabinet Secretary has accepted are far from clear. While they recognise the full transfer of business from Cooper to Dundee, they leave open the door for the transfer in the longer term of business from Forfar to Dundee also. And I would like the Cabinet Secretary to give us more detail on this proposal and how he plans to do that. In light of the admission 3 weeks ago to this committee by Eric McQueen that further court closures are planned, are we to assume that more, and for example Forfar, are currently being considered for closure? I would like clarification on that, certainly.
Cabinet Secretary, yes.
I know the member was absent when the Lord President and the Chief Executive gave their evidence, but I would ask her to accept that these matters, in terms of how the law prescribes it, come from them. It is not a decision I make, and I'll comment upon that, but does she not accept that any changes come from the Lord President, the Scottish Court Service and the Chief Executive, and therefore she has to ask them about future matters, whether at the previous week when she was absent, or indeed in a further correspondence?
Convener, I'm afraid I don't accept what the Cabinet Secretary is saying. I think
Can I just say before we say anything that Miss Mara was absent on parliamentary business? Right.
Thank you, Convener. I don't accept what the Cabinet Secretary says because this is a proposal being put before Parliament by his government, and we have said in the Chamber before, he can seek to pass the buck to the Lord President, to the Scottish Court Service, to anyone he likes, but he is sitting before this committee today. These are his proposals, this is his budget, and he must take responsibility for it. So I would like clarification on his future plans. I would like to know specifically on the issue of Dundee how the Cabinet Secretary expects Dundee Sheriff Court to seamlessly handle increased business from Cooper and Arbroath, because those in the know are clearly and vocally opposed to these proposals. The Sheriffs Association has had this to say on the proposal to close Cooper and transfer business to Dundee. They said, "We are very concerned that the existing accommodation in Dundee simply does not have sufficient capacity in terms of appropriate courtrooms and sufficient court delays to deal timiously with all the sheriff and jury business envisaged, never mind the additional civil business. The consequence will not merely be delay in terms of justice delayed being justice denied. It may be that time bars in custody or on bail will simply not be able to be met. We are unaware of detailed analysis or information being available to assess these justifiable concerns. No final and irreversible decision on closure of Cooper Sheriff Court should be taken without such information." And these are not my words, but these are the words of the Sheriffs Association. I think the reality, Cabinet Secretary, is that we simply do not have enough information to make any decisions like this today. We have already seen the business case for this torn apart by the forensic accountancy that was done in the case of Haddington. And when we look to the government's future proposals, not just to close more courts, but for wider reform of the justice system, the landscape becomes more uncertain and the impact for Dundee more unclear. As I've said to you in the Chamber before, your proposed removal of corroboration, cuts to legal aid, which you have already voted through this Parliament, the alteration of exclusive competence of the Court of Session, which will see more personal injury cases moved down to the Sheriff Court. All of these will have an impact on business going through our courts. And it can't be argued, as you have tried to do in the Chamber, that fewer cases today mean fewer cases tomorrow, particularly when your government is trying to put all this legislation through the Chamber at the moment. The Cabinet Secretary, I would put to him that your government is giving up on many elements of local justice in our communities. We're seeing a fall in prosecutions. We are seeing an increase in fiscal fines at the moment. And I would put it to the Cabinet Secretary that actually the closure of these local courts is in many ways sending out a signal to Scotland that you're giving up on local justice. And as I said at the start, the Cabinet Secretary continues to pass the buck on this. The Lord President, the Scottish Court Service, he says they make operational decisions. Well, he makes the political decisions, and these are his decisions. And even if we accept that the Lord President and the Scottish Court Service have a role to play, we must also accept that the Cabinet Secretary is the democratically elected decision maker with responsibility to set this budget and make laws for our justice system. No one else can do this, and we in this committee and Parliament are those responsible for approving these laws. I think it's time that the Cabinet Secretary took responsibility for the 80% cut in the Scottish Court Service budget, which has not been replicated across other Scottish Government budgets. We should not be satisfied with the closure of courts across Scotland being hidden behind a Scottish Court Service consultation and then brought to Parliament in the form of statutory instruments. Convener, I would just like to be reflective for a moment, because I really believe that in 10, 20 or 30 years' time, we will look back on these proposals and this government's decision with a lot of regret. And I think we will say in years to come that justice is best done in our local communities, by juries of local peers and judgments by sheriffs with local knowledge. We will want to recreate our local court system that has survived, as Ian Gray said, for 500 years. I think this is a very, very short-term proposal. When 95% of consultation responses were against these plans, when both Angus and Fife councils have unanimously voted to oppose the closure of Arbroath and Cooper Sheriff Courts, it's only right that MSPs from these areas and MSPs from all areas in Scotland where courts are closing stand up for those they represent today, and I would urge fellow members of the Justice Committee to support Lewis MacDonald's motion to annul.
Thank you very much, Jenny. Elaine Murray, you've been very patient.
Thank you very much, Convener. I'm sure for both the Cabinet Secretary and myself there's a certain degree of déjà vu, because this is the second time we've discussed the closure of Adam Justice of the Peace Court. That was first proposed in the previous session of Parliament, but at that time the Justice Committee decided that they would not agree to the closure of the Justice of the Peace Court. Now, I recently circulated to all members of this committee copies of a motion which was passed unanimously by Dumfries and Galloway Council at a meeting of the full council. And that was not just by Labour and Conservative and Liberal Democrat councillors who supported that. That motion was supported by SNP councillors and by independent councillors. It was a unanimous decision of that council. And indeed, I am in receipt of a letter, and others who represent my area may also be in receipt of a letter from the Senior Manager of Legal and Regulatory Services on behalf of the Chief Executive of Dumfries and Galloway Council, asking us to oppose these closures. The closures in Dumfries and Galloway are Annan Justice of the Peace Court in my constituency, but also Kirkcudbright Sheriff Court in Galloway and Westmont, Dumfries constituency, Alex Ferguson's constituency, and the transfer of jury trials away from Stranraer. Now, Dumfries and Galloway area is a very large, predominantly rural area. It's an area with many different communities, very different and distinct communities, communities which are very proud of the traditions, and we see it never more clearly than at this time of year with our galas and common ridings and so on. Kirkcudbright has a history of 550 years of courts. Annan, the Royal Borough of Annan in my constituency, has some 700 years of court history, and local people are concerned that that will be lost. I just want to recap to you briefly, and I know you've had a submission from the Council in respect of these orders, but just to go through with you very briefly why councillors of all colours and council officials on Dumfries and Galloway Council oppose these measures. The first is the travel distances, because it is a large area and an area not well served by public transport. Dumfries and Galloway Council, in fact, are concerned that that could even lead to the non-reporting of crime due to witnesses being concerned about the extensive travel being involved in court appearances. In Annan, the outlying districts could actually mean people having a round trip of up to 80 miles, and I believe at Kirkcudbright it could be even as much as a 100-mile round trip where people to lose their district court.
I'm very concerned that people should not report crime. That's why I'm surprised that the member should say that, given that we have support for these proposals of the Lord President from Police Service of Scotland and indeed from the Crown Office and Procurator of Fiscal Service, and indeed the difficulties for travel have been taken on board and will be addressed by the Crown Office. But I don't know if she would care to reflect upon those comments,
can I just
given
comment?
the police view.
I will read directly from you from the submission from Dumfries and Galloway Council, which says the Council is concerned that the proposals could lead to the non-reporting of crime due to witnesses being concerned about being involved in court appearances requiring extensive travel and the commitment that would bring in time away from home or work, and also the initial outlay of expense involved. That is actually the view of Regulatory and Legal Services on Dumfries and Galloway Council, who gave that evidence to the committee. They say also that the Council is...
spat for a moment, but I'll read it later.
Yes. I can
I'm so
provide
sorry,
that too.
Distracted by the Deputy Convener here for a moment.
Can I also say that
apologies.
the Council is concerned about resource issues for the staffing of criminal justice social work services, and also resource issues for the police in terms of their staffing. At the moment, for example, in Annan, the police are immediately opposite the court and can easily access the court. And they are concerned, as Ian Gray has said in his area, about the impact on firms of solicitors in Annan, Kirkcudbright and Stranraer. We have local solicitor services in all those areas. It would be a diminution in services to those communities should those firms have to close and people become more and more reliant on firms in Dumfries or indeed further away. What I'm asking, particularly those committee members from the SNP group here and the independents, please don't just listen to this. This is not just party political in Dumfries and Galloway. It has the unanimous support of all parties. So if you don't want to listen to me, will you please respect the views of SNP councillors, respect the views of independent councillors on Dumfries and Galloway Council, and at the very least allow further discussion in Parliament by supporting Lewis MacDonald's amendments, motions to annul today.
Thank you very much, Elaine. Thank you. Claudia Beamish, please. Oh, sorry, Sandra White next. I'm trying to do a bit of balance here. Sandra White, then Claudia.
Okay, thank you. Thank you very much, Convener. I look forward to what Claudia and others have to say as well. I mean, I've sat in the Justice Committee. I've listened to the evidence that's been brought forward by witnesses, both written and obviously verbal evidence also, and I just want to try and get it all together. And I did genuinely listen to the concerns that people had brought forward, but I also listened to Lord Gill last week and was very impressed by his contribution. He didn't deem it as court closures. It's basically looking at the justice system as it moves ahead. But there's a couple of things I wanted to raise, what's been raised today. The first question that Lewis MacDonald was asked when you were putting forward your submission, Lewis, was, what courts would you close? And you did admit that there were some courts that you would close. I've just listened to Elaine. Now I've listened to everyone, and nobody wants to close their courts in their local areas. Now, taking forward from that, and listen to Alison also, and the questions that I asked Alison about access, and definitely Children First had said that some courts were not fit for people to go there, not wheelchair friendly, not children friendly. And in fact, I think there's a report that says that Haddington Court does not have a specialised area for vulnerable witnesses. I'm sure that's been part of the evidence also. So you've got to take all these things in the round. And when we listen to Lord Gill's submission, and also obviously victim support as well in regards to video conferencing, it may not be the be-all and end-all, but we did have assurances that any courts that were closed, they would be up and running with... Yes, certainly.
I think Sandra White makes a very fair point that we have to take all these things in the round, and I think in his introductory remarks, Lewis MacDonald said that he was not arguing the case for never shutting any court ever, and I take the comments Sandra White makes about some of the facilities at Haddington. But if we are to take all these things in the round, then those of us like myself who face the closure of our courts need to see some actual proposals come forward. There is no proposal to provide video link facilities so that vulnerable witnesses from my constituency don't have to travel into Edinburgh. If these proposals are coming forward, then we should have them before we consider the closure. What we have in front of us today is a decision to delay this decision by presenting it to the whole of the Parliament. So if we are to take things in the round, I would argue that members of the committee should support Mr MacDonald's motion.
Just by way of information, we have something in from the Cabinet Secretary and video links, which is in the papers that we have. I don't know if the members had the opportunity to see it, because we did challenge at committee about that, asked for something before this debate. I'm happy to pass it to the member so you can see what it says about it.
I thank the convener for that. I was just going to raise the issue that when we asked Mr McQueen last week if he would provide us with further evidence and assure us that any courts that were going to be closed would have video link up and running in that particular aspect, and we were assured we would have those figures. To be perfectly honest with you, I haven't seen that paper either, so it's maybe amongst my...
Pass around, but
it's maybe amongst my... I haven't read it yet either, so I
page 14
right,
of
page
your
14, I haven't looked at that.
Read it.
That's fine. I'm sure you will read it out for Mr Gray, but we were given assurances that this would happen. And as I said before, I think we have to look at it, the whole thing in the round. Now, Children First, Women's Aid, various other organisations have said that for vulnerable witnesses, and particularly for children, it's very difficult, not just for the travelling aspect of it, but to have to bring them into court. And we had assurances from Mr McQueen that they would be looking at pushing out further, as I mentioned in my intervention. Can I just finish up? You comment then, I will in a minute, in regard to Dundee, where children's hearings and that aspect are heard in a different venue, and it worked very, very well, and assurance that this would be rolled out. So I'm taking on board what they've been saying also. But yes, Jenny, I'll let you.
Thank the member for giving way. I mean, would the member accept that, for instance, in the northeast of Scotland, there's a special suite and facility for vulnerable witnesses in Arbroath Sheriff Court. That's one of the courts to close, and it was recently refurbished at a cost to the Scottish Court Service. But that business is being transferred to Forfar, where there is no such facility. So, if these considerations are being taken in, why is that decision being made?
I think you need to ask the court services, but to answer what you were saying, we certainly heard evidence from Forfar and from Arbroath, and the assurances we were given that this would be replicated in the Arbroath court, and that's certainly in the evidence in the papers there, and I have read those particular parts as well. But I wanted to just go on, if I may, convener, if you can tell me when I'm went on too long, basically. When you look at, as I said, Lord Gill's evidence, and and I think it was actually Jenny that raised this one regarding civil business, etc. We're basically saying here, and Lord Gill had basically said that 80% of High Court trials take place in Glasgow, Aberdeen and Edinburgh. He also mentioned having flexibility of measures. And when I did ask Lord Gill about, which I'm interested in, is how victims are treated, how they get access to justice as well, he said that the moment, the way the court is structured, is less efficient, and if we go forward in improving the sheriff court system and the other court system, there'll be less downtime, no gaps, and a rolling programme, and therefore we'd be able to have a rolling programme. People wouldn't be sitting around the courts, and witnesses would be able to go forward there. We also get the assurances that if we had witnesses who are feeling vulnerable and travelling on the same bus, and I must admit, coming from Glasgow, one of the biggest courts there, witnesses stand outside sometimes together as well, along with the perpetrator. So I'm pretty much, au fait with that. But they did say that they would look at that specifically as it happens just now. And people do, get treatment that they don't have to travel on bus, they can get a taxi and that type of thing. But I just want to say that, you're talking about 86% of the trials as well are held in certain areas too. And I must admit, I keep quoting Lord Gill, but I suppose he's the person who's behind all this stuff as well. And we mentioned the specialised... Well, no,
if you're going to...
I'm not going to get into a spat.
You can't just have a little discussion without across the chamber.
I'm sure the Cabinet Secretary...
Excuse me a minute.
Sorry.
I like to sometimes be noticed, just
I apologise.
If you're going to intervene properly, okay?
Right. I apologise for that, convener, for shouting across, but I'm sure the Cabinet Secretary can answer that particular one as well. But as I say, I'm looking at in the round. I take on board the concerns that everyone has brought forward, but I think to have court system and access to justice for people, which is all about the victims, we need to move into the 21st century. and we won't be going back. We'll have to move forward. And I'm not talking about the monetary terms, I'm talking about access. And if we can have access to justice without the whole court procedure, as already been mentioned about specialisation, I think John Finney raised that particular point. If we don't...
With the witness, she's a witness now, it's all getting to us. Graham, do you want to take one?
Yes, all right.
Right.
Thanks, Sandra. Has she noted the comment from the Scottish Police Service that says, should witnesses have further to travel to court, they will be discouraged from attending court due to the inconvenience this presents, which could in turn lead to them disengaging from the criminal justice process, i.e. not reporting crimes and coming forward as witnesses. In these rural communities, is that not a serious concern for us?
I note the comments that you're making from the paper from the police, but there's also comments from other organisations. ACPOS, I think, I'm sure is one of them as well, which has said, yes, but there's also been quotes previous to that, which basically says that they will be looked at and won't need to travel by bus, they'll be able to get taxis. Procurator Fiscal has that. No, yes, it's in the papers.
Sandra, can I get you to, you've taken quite a lot of interventions, so another couple of minutes, maybe, or a minute?
It's in the papers there, the Procurator Fiscal. And I think we asked that of witnesses, that they said they would be able to get taxis, and that was assured. So I'm looking at it in the round, and I'm also taking on board Lord Gill's proposal that basically we should be moving forward to the 21st century, looking at specialisation as well.
Right, thank you. Claudia, you've been very patient, and then I've got John Finney.
Thank you, Convener, and good morning, Cabinet Secretary. And others around the table. It would seem to me, as a member of the Scottish Parliament who is not a member of this committee, that even hearing the evidence this morning, that there's so much conflicting evidence and there's so much determination by local communities that they need local access to justice, that at the very least, as someone who's come into this as a parliamentarian rather than a member of this committee, that this should be coming to the full Parliament. And that's where I start and will also end my remarks. I've come today to this committee because I've been contacted by many constituents across the south of Scotland about access to local justice and the issue of court closures and the changes to the court system throughout South Scotland. And I want to identify myself with the remarks of other constituency MSPs and also with my colleague Graham Pearson about this issue, talking from a South Scotland perspective. There are the similar issues across South Scotland and indeed, if I might say, across rural Scotland in relation to access to justice. And many of those have been highlighted today already, so I'm not going to go into detail. But much of South Scotland is rural. There are very different communities in the south of Scotland, and there is a history of local courts that support the access to local justice, which I believe is still important in the 21st century. And if we're going to look at this in the round, we need to look at it as parliamentarians right across the Parliament. The constituents have written to me about the transport issue which has been raised, and I frankly, to be blunt, don't think that a solution of putting people in taxis to avoid what my colleague Sandra White has raised about people going on the same buses is a solution to the issue of the concerns of often vulnerable witnesses and also victims who may end up travelling on the same public transport. Indeed, transport has been highlighted to me by constituents because the transport issue in terms of public transport is that often there isn't public transport to get onto in some of the areas in South Scotland where people would have to get to a court. And so they would then have to get to a local transport hub and then travel on in the case of, say, East Lothian and Haddington, which my colleague Ian Gray has raised, right the way up to Edinburgh. So I think also the concerns that have been raised about local work and town centres and the contribution that local courts make should be taken into account in relation to rural strategies and the support that those should bring to local justice. My colleague Elaine Murray has highlighted... yes.
Take an intervention?
Yes.
Thank the member very much for taking an intervention. And there's lots of submissions from ACPOS and various paragraphs you can read out of. And you were mentioning earlier about the travel, etc., of vulnerable witnesses. Would you agree with ACPOS then when they mention about the High Court circuit when they say that video link CCTV usage in alignment with the special measures that have been available through the vulnerable witnesses legislation, the knowledge that these measures are available may encourage the public to engage more freely in the overall criminal justice process?
In terms of some vulnerable witnesses, I think that those sort of video links are extremely important. But this doesn't alter the fact that... I understand that, but this is only part of the picture. Many witnesses, I would say, to this committee today feel vulnerable, whether they are identified in that particular category or not. And I think that all witnesses can feel very vulnerable in terms of the travelling that they would have to take.
Just a point of information, the committee has also been looking at the witnesses, vulnerable witnesses bill, and there will be issues there where people will be able to be designated as vulnerable witnesses. So there is a shift coming that way as well. We're moving further into protecting people. That's just a point of information.
Right. Okay, thank you. In terms of, I want to acknowledge that, of course, there is a need for there to be cutting of costs, but I don't think that this is the way to go forward. And I do believe that as an ex-convener of the Equal Opportunities Committee, I'm becoming increasingly convinced as the morning has gone on that the equality issue really needs further discussion in relation to disabled people, in relation to women and children,
Would you take one from John
Yes.
Finney? John.
Thank you. I'm grateful for the member taking an intervention. I don't know if the members had the opportunity to have a look at the equality impact assessment made in respect of the proposals. And in relation to the issue of age, and I quote, no specific negative impact on any group has been identified. In relation to gender, no specific impact. I would commend examination of the document to the member.
Right. Well, I haven't had the opportunity to look at the equality impact assessment, but I would certainly say that from my own perspective, as a representative of the whole of South Scotland, that I would really question, to be blunt, the issue of age and access to transport to travel considerable distances, up to 200 miles in Dumfries and Galloway round trip, for people who are elderly. So I would frankly question that. The only other comment, there have been comments about reporting of crime, and I don't want to go into that. I think those arguments have been rehearsed, but I would support my colleague Elaine Murray, and I was also sent the letter from Dumfries and Galloway legal and regulatory services supported across the parties. But I really only want to end by saying that I do believe that it should go to the whole Parliament, and on behalf of my constituents in South Scotland, that is really why I've come along today. Thank you.
Thank you very much, Claudia. I now have John Finney, please.
Every day I'm learning more, and today is the first opportunity I've had to be involved in the annulment process in Parliament. Now, the proposer, Lewis Macdonald, talked about requesting further debate on the issue, and that was followed by Alison, who also talked about the matter being properly debated. But I did note that, notwithstanding accepting interventions, neither used their full time to debate the issue. So I'm not aware of any I'm not aware of any efforts to frustrate debate. Can I say where I come in on this particular issue is that I have long-standing interest in domestic abuse cases. I've raised issues with that in the Parliament previously. I raised a specific issue with the Cabinet Secretary in a question about a dedicated domestic abuse court for the Highlands. I have to say that wasn't forthcoming. I nonetheless included that in a detailed submission I put to the consultation on this process. Now, I don't lend blind support, quote unquote, to anything, and as regards Mr Lamont's outburst earlier, I won't take lecture from the Tories on anything, least of all anything remotely connected with social justice. I think we have to act responsibly in this committee and deal with the issues in front of us. And I think this issue has to be seen in the context of other developments that have been alluded to by other people who have spoken. I particularly refer to Lords Carlaway and Gill, and as you mentioned recently yourself, Convener, the victims and witnesses, where, and there seems to be broad consensus already on this, where a lot of consideration will go into the support that's provided to witnesses. Now, in relation to that, I got in touch with the Cabinet Secretary and the Scottish Court Service about an extension of the remote facilities that were available. It seemed to me to be an opportunity to work with partner agencies. And I have to say that the initial response was, and I quote, no plans. I'm delighted that that was subsequently revised, and I'm even more pleased that it was extended beyond the specific location I was referring to, namely Dingwall, and it's been agreed in relation to all the areas that have been identified for closure.
I wonder if Mr Finney would take an intervention.
Most certainly.
I'd be very interested to know from Mr Finney what he believes are the types of court cases where it would not be appropriate to use video links to substitute for appearing in person at court.
Well, that of course will be part of the assessment that's put in place with regard to the vulnerability of the complainer, the victim, whoever, and it will vary from case to case. That's quite clear. I think we'll want each individual case considered on its merits. Now, the issue of distance has been mentioned, and whilst there's passing reference to it, certainly for some constituents, the changes will, and I particularly refer to, for instance, my own area, the Back Isle, the facilities will be closer. The issue, whilst accepting that my colleague Claudia Beamish doesn't accept the content, I would again commend people to look at, particularly on pages 12 and 13 of the Equality Impact Assessment, which of course is dealing with the overall package, and it isn't as punitive as people would suggest. Indeed, no specific negative impact in any group seems to me to be quite a compelling... yes, certainly.
How do you respond to the concerns and the warnings that came from the Association of the Directors of Social Work and from the Children's Commissioner, who said that there was definitely an impact on children and young people? I think that the Equalities Impact Assessment is a cursory one, and would you not give more heed to the ADSW and the Children's Commissioner?
Well, the assessment is across the round rather than specifics, and I think there will be specific examples, as we know, in relation to buildings that have been alluded to. So longer term, we're seeking improvement, but I certainly am not questioning the integrity of people compiling this assessment, which seems to me to have been done entirely good faith. The issue of travel I find interesting because, of course, throughout my area, people are routinely travelling distances, accused and witnesses, sometimes in small confines of a ferry, as I've alluded to, for instance, if you take Lochmaddy Sheriff Court. So the idea that there's some additional problem by someone perhaps requiring to stay another 10-15 minutes on public transport I think is wrong, and particularly in relation to Rothsey, we've heard that the video links would indeed preclude that, and again, it's all about the assessments that's made with the vulnerability of the witnesses and complainer. The other issue that I'm pleased, and again this was acknowledged last week or the week before by the Cabinet Secretary, was a proposal forthcoming from Scottish Women's Aid that the clustering of cases would not only make things more easily managed for the Scottish Court Service, it would make easier for the women's aid groups, indeed for the public agencies supporting that, and in line with the proposals that are forthcoming with regard to specialisms, afford the opportunity for a specialism to be built up in relation to domestic abuse cases. I don't think any of us would choose to be in the position we're here. We're here because of unionist cuts. That's not in dispute. I think there are different views as to the role of this committee. I think in life you have the opportunity to make easy decisions and difficult decisions. Certainly, on a personal level, the easy decision for me would be to say, well, let's pass it on. But the reality is that we wouldn't be passing on decisions that were seen to be favourable. I think this committee has the wherewithal. I'm not aware of anyone frustrating debate. I'm not aware of anyone refusing to come forward with information. There are challenges ahead. I'm certainly content that rather than run to the press with issues, I ran to officials to try and mitigate the concerns I had. These were about the extensions to vulnerable witnesses, about the clustering of cases, and in the long term I hope to see continuing progress. I won't be supporting Lewis Macdonald.
Thank you, John. Roderick Campbell. Roderick.
Thank you, Convener. For the record, can I just correct something that John Lamont said in his earlier speech about something I reported to have said? I think he's incorrectly quoting from the press. I think, for the record, could I just what I said in the Chamber on 23rd of April, I think, was the proposals for Fife are severe. The removal of sheriff and jury work from Kirkcaldy to Dunfermline in the west means that the court will receive more business than ever. While I understand the loss felt in Kirkcaldy, at least people there will retain a court, unlike my own constituents. Although I accept the case for removing a small number of sheriff and jury cases from Cooper, it's difficult to accept the removal of the day-to-day civil and criminal work. That will have an economic impact. I remain of the view that it will have an economic impact, and these proposals are clearly not good news for my constituency. But perhaps I might now turn on to two of the factors which the Scottish Courts Service consultation kind of rather based their proposals on. Firstly, the issue of capacity. Well, the Scottish Court Service have given evidence as to their views as to the abilities of various courts to take work from other sheriff courts which are proposed for closure. It's a difficult one, but I don't think that as an individual and as a member of this committee, I'm in a position to contradict what the Scottish Court Service say on the subject. However, if their calculations are wrong, I trust there will be repercussions. We cannot be in the position as a parliament and a government of rubber stamping proposals which turn out to be incorrect. But I accept briefly, yes.
I simply say to Roddy that if a court, in this case Edinburgh, is achieving 58.4% of cases disposed of within a 20-week target, when the Scottish Minister's own target is 85%, surely that is a sign that they are not able to deal with the volume of business they already have. That's the Scottish Court Service's own figures, so their argument is undermined by their own performance figures.
I hear what he says, what the member says, but I'm rather perplexed by some of these statistics. I tried to obtain similar statistics for Tayside Central and Fife and was told they're not maintained. I'm not entirely sure where your statistics came from. I appreciate that what you're saying is in good faith. But I'm not in a position to contradict what the Scottish Court Service say on the point. All I do say is if they've got it wrong, there should be repercussions.
I wonder if Mr Campbell would take a further intervention.
I'm doubtful that I'm not going to make progress if I keep taking interventions. So I hear what's said in relation to that. In relation to issues of travelling in terms of legitimate concerns about increased travelling time and that dissuading people from participating, obviously I have sympathy for that. When the consultation response was produced, obviously we had tables produced showing the numbers of witnesses who would be affected, numbers of witnesses who would have less of a journey, those having to travel more than 10 miles and those under 10 miles. I have to say I tried to engage closely with my own constituents in relation to that. In the part of my constituency which is, I would have expected to be most affected by these proposals in the East Neuk, I wrote to every community council and did not receive one response to the issue. And in my postbag from the East Neuk, again, I've had a couple of letters on this whole issue. So it doesn't seem to me that that my voters in areas that are most affected are unduly troubled by these proposals, although I accept that for individual witnesses that's no consolation at all. I have to say also, however, that there may be few in numbers, but I'm sure that there are witnesses at the current time who have difficult journeys to current courts. Moving on, I think just perhaps briefly to the question of local reporting. I think that's an issue that the Scottish Court Service have not taken seriously enough, and I question Mr McQueen on that. And I trust that that he will make contact with those courts which are being closed with the papers in there and work to develop an early plan for reporting court proceedings in the future. I think it is important that local communities retain knowledge of what's going on in courts in terms of people in their communities. In relation to a specific point affecting Fife, the location of Fife Council social work, and the difficulties that they will have in moving to a different local authority area. I do think the Scottish Court Service have underestimated that, and I was not encouraged in the evidence sessions by Eric McQueen's kind of admission that there had been no recent discussions. I think we need to take these kind of issues seriously, though I accept fully that the trend must be to have as few social workers actually being called to give evidence in court as possible. Local lawyers, the impact, well, I have no doubt that these proposals will be bad news for local lawyers throughout Scotland in various parts, and quite clearly local solicitors will have to travel further on occasions to deal with cases. They will, however, and they continue to operate in a challenging world. We have the problems already with legal aid and the availability of it, but I'm pleased that legal aid is in a rather better state here than it is south of the border. These are no doubt going to be difficult for solicitors, going to be particularly difficult for lawyers from my own constituency who have currently no offices in Dundee. But I accept that kind of being in business as a lawyer is a challenge, and you've got to look for opportunities as well as complain about the disadvantages that are offered. But I don't minimise the impact that that will have on the local community. In relation to other smaller issues, sale of buildings issues, the Scottish Court Service, I think, wisely put a very low figure of £2 million as for possible capital receipts from the sale of buildings. I've found nothing to suggest that these sales are going to be easy. In courts south of the border, we all know there's substantial evidence that courts are not selling when they're put on the open market. I checked yesterday with Fife Council, and they have no operating interest in acquiring the Cooper Sheriff Court. So my concerns as to this being a substantial white elephant remain. I'm concerned that we may have a building here that, if it's closed, will remain closed for some considerable period of time. But I would be delighted to be proved wrong on that one. And I think we ought to remember that with courts generally across the board, there will be operating costs until buildings are closed. In relation to the maintenance budget issues, this is a particularly tricky one, but even with the money that's now been spent, following a slight increase in the Scottish budget, we still have an outstanding maintenance budget of about 53 million. That's a huge problem for the government and the Parliament as a whole. No one has actually addressed that today. And although any closures here will have a relatively limited impact on that, that's a huge problem that remains in the background. So we can't wish away these problems.
Well, it's actually been very generous because it's over time.
I'm over time already.
Yes, I mean, I have a note.
Sorry, well, I better not take any
I have a note here of time that people get.
Okay. Sorry, convener, could I have your indulgence to carry on a bit longer?
Well, how much longer are you anticipating indulging? I'm going to indulge you in.
2 or 3 minutes, possibly?
2 minutes.
Yeah, okay. Can I just turn on to questions of local delivery of justice? I remain of the view that for most people in North East Fife, local delivery of justice means south of the Tay, that the Tay has some at least psychological impact, which isn't really reflected in the consultation response. However, I do believe that if a sheriff in Dundee hears a case, he will do so in accordance with established judicial principles, and the quality of justice will not diminish. As to the change in privative limits, the possible change to 150,000, I agree that in an ideal world these matters should have been considered at the same time as court closures, but that's not where we are. Looking at Fife as a whole, I refer again to the fact that Kirkcaldy has a £2 million maintenance backlog deficit. In my discussions with the SCS, they have indicated that they would prefer not to spend that money. there is obviously talk of a feasibility study for a Fife Justice Centre. I accept that that's a medium to long-term proposal, but it doesn't seem to me that delaying a feasibility study would gain anything. I think the sooner we get on with the feasibility study, the better. And also, the Scottish Court Service have accepted to me that they will keep under review proposals for the administration of justice in Fife. I regret that in a number of discussions I've failed to change the Cabinet Secretary's mind as to the closure of the court in Cooper. I regret that. I remain of the view that that's bad news. I accept, however, that the statutory instruments we're required to consider today refer to a lot more courts than just Cooper, Sheriff and JP courts. So in my role as a member of the Justice Committee, I have to take the wider role. My reservations remain. I'm going to press hard for the consideration of the administration of justice in Fife to be kept under review. I think the economic impact has been understated. I'm happy that there are no compulsory redundancies for Scottish Court Service workers, but I am certain that there is an economic impact which has not been today highlighted by the Scottish Court Service. I've had an initial discussion with the government on that. I will
very tolerant,
yeah,
but I know you're used to being paid as a lawyer by the length you speak.
Can you just allow me to finish this final point, Convener? I've had initial discussions, and I will continue to press this government, not only in relation to Cooper, but to consider closely the potential economic impact on particular communities arising from the closure of courts. I think this is a serious issue which perhaps was not the Scottish Court Service's baby, but certainly is one for the Scottish Government. But I'm confident that the Scottish Government will listen to my comments in that regard and take note.
Is that it? At last. Yeah. Right, John, you've been it's your first visit here, isn't it?
It is,
Convener. Right, very, very welcome.
And
Claudia, others who've not been here before. It's a great wee committee, this, sometimes. John.
Sometimes. Well, hopefully this is one of the times when it is very good. So thank you very much, Convener. And I speak specifically about Motherwell JP Court. Very often we hear repeated references from the Scottish Government about the need for joined-up thinking and holistic approaches. But in practice, this is often lacking. You know, with the closure of Motherwell JP Court, a good example of that. By looking at the costs of court operations in isolation, we ignore the costs of others of closures. In some cases, the courts might be a little better off, but the people they serve will not be. Financial arguments for closing local courts are based on false economies. And Motherwell is said not to be a busy court, despite over 2,500 new summary criminal complaints being brought before the court in 2011-12, with 660 trials being called. It is also said that Motherwell JP Court is not modern enough or up to standard. I do not agree with that description painted by the court service, that there is a lack of adequate interview space, witness facilities and cell accommodation. For North Lanarkshire Council invested heavily in all those areas, modernising the district court prior to the handover to the JP court system. The local economy will suffer, with North Lanarkshire Council losing tens of thousands of pounds from the rental of their Motherwell premises and the Scottish Court Service contribution to energy costs and cleaning. They will lose further large amounts from the closure of Cumbernauld and Coat Bridge. Now, North Lanarkshire Council may be able to offset a little by converting the premises to other uses and attempting to sell off property freed up elsewhere. But none of this is cost-free or easy, and some of it, such as cleaning services, has implications for the workforce and possible redundancies. The loss of the local access to justice is likely to significantly increase the incidence of failure by accused persons and witnesses attending court, adversely affect fine collection and lead to more frequent instances of accused persons and witnesses travelling on the same transport to and from court, and hence greater risk of intimidation or inflammatory contact. Now, these are likely to entail financial consequences, such as warrants for arrest being issued for non-appearance at court and the failure to pay fines and parties having to be detained in cells probably overnight or longer, and other indirect costs to other agencies. Now, some costs are not immediately obvious. They may not add up to someone else's budget as such, but they are what economists call opportunity costs. Additional time spent by police officers, social workers travelling and waiting to give evidence because the court is further away is time that will not be spent on other tasks. There are also considerations on which we cannot put a cost. Access to justice will be harmed by any moves that make it harder for people to attend and participate in the justice process, making witnesses more reluctant to give evidence, increasing pressure on participants to accept outcomes and circumvent the court process. Well, while there may be good reasons to do this, making the alternative more difficult is not one of them. Decisions such as this should be made with regard to all consequences, not just the ones that show in the bottom line of the Scottish Court Service balance sheet. So Convener, I would hope that the members of the committee would support Lewis Macdonald's motion to annul the order. Thank you.
Thank you very much. And I'm going to call myself now. First of all, I'll just do a little bit, because I was mentioned in dispatches, I think, about Peebles Sheriff Court. And what I do as a constituency member is outside this committee room. So, of course, I've argued long and hard in the chamber. I also responded to the consultation. My A plan was that Peebles shouldn't close. My B plan was that if Peebles was to close, the business should go to Selkirk in the interim and not to Edinburgh. And I won that one with the court service. So at least we're keeping within the borders and introduced into the idea of a justice centre. And I remain there campaigning on it, out with this chamber and lobbying all over the place wherever I can, including the council and so on. But that's a separate matter from sitting here. Probably as convener it's a wee bit more difficult. It shouldn't be, because I'm just a committee member as well. But I say with respect to Lewis Macdonald, you know, when Peebles Sheriff Court, the actual courthouse is closed, of course, these were different times, different financial constraints at the time. And I would also add that the Peebles lawyers actually agree with me about business going to Selkirk. They're not unhappy, and they've said so publicly. So the lawyers, I say to Roddy Campbell, are on my team, actually, in this matter, the local lawyers. But what we have now is a different choice being made, and quite rightly, you, Alison, talked about governments making choices. And in the justice budget, what I see as a choice, one of the choices I see has been made is to protect the civil legal aid budget in Scotland as opposed to buildings. That's terribly important. I used to practice civil legal aid cases, and I'm not going to make a big thing about what's happening south of the border, but I can't completely ignore it that there's people down south who will not be able to have legal representation for contact with their children, for welfare issues and so on, that they will still have in Scotland. So if you ask me to make a choice, I'd rather have people who don't have very much money and require legal support to have it than to have a building, if that's a choice that has to be made. And I was really on the cusp about this until I heard Lord Gill's evidence. I know it's been quoted before, and it's turning, people are getting maybe a wee bit turned off about it, but I was interested in the question, I've got it with me, the question that John Lamont put to, I'm watching my time by the way, what John Lamont put to Lord Gill. When you asked John, are the changes about saving money or about delivering a better justice system for Scotland? Is a very good and a very fair question. And Lord Gill answered, the impetus for all of this work arose from the need to save money, as I have explained. But one of the outcomes of the cost constraints that we are suffering from has been to make us question certain assumptions that we would have continued to make in more prosperous times. When we find ourselves having to take a long, hard look at the existing system, certain weaknesses that we had not noticed over the years became obvious and apparent. My feeling is that a perfectly good intellectual case could be made for the changes, even if we were not living in these rather unusual economic circumstances. In a modern Scotland, there is a good case to be made for having centres of specialisation and excellence and making most efficient use of resources. If we were to sit down today and plan a justice system for Scotland based on a network of high courts and sheriff courts, it would be nothing like the present pattern, which is based on a Victorian model. Now, This man has worked, can I just finish a minute? This man's worked his way through the ranks. I mean, we did have evidence, and you were there, that he'd appeared in sheriff courts. You know, the buck stops with him. If this all crashes down and justice, talking about justice, the key to this is not properly done and seen to be done, the buck will stop where those words are, that he is looking to provide a better justice system. And I have to say that I was at something yesterday with a lot of lawyers and judges. I was just chairing it, but it was interesting to talk about all the other changes that are coming down, which are embraced in this, which do require a different kind of sheriff court system to deal with the more technical and specialised cases that will be arriving. And I also, I'll take you in a minute, Lewis, I also understood that this was not the fact that we would just be stuck with these particular sheriff courts, that there would be opportunities by Sheriff Drummond, who I have to say I encouraged to attend because I know he would freelance because he's about to retire, that we would be opportunities for sheriffs to say, I want this particular, perhaps through the sheriff principal, this particular hearing, this particular court sitting to be in this area because it's suitable, let's say, to a child welfare hearing. Lewis.
Thank you very much, Convener. Given what Lord Gill did say about technology and about change in the court system, I wonder if you drew any conclusions as to the future prospects of the courts which in the borders which will not be closed in the current.
Well, you know, he did, that was raised with him, and he said that wasn't on his agenda and it wasn't part of the consultation. Neither, in fact, in fairness, were justice centres. That arose from the committee pushing. I mean, our job was also to push on other issues, which I think we also did, which was on video conferencing. We insisted to find something about video conferencing, and we got something back. We insisted to find out what the police position would be about extra police costs. We have something from ACPOS, and the Chief Constable says it's cost neutral. Now, I don't like the idea of sheriff courts or sheriff sittings not to be in local areas, but I'm here to sit hearing the evidence in a dispassionate fashion. And in a dispassionate fashion, when I hear the senior judge in Scotland telling me this is the way forward, telling us that, with the other issues built in, which we can keep reviewing, then I have to say I moved from being very sceptical to saying, well, I think the man has made his case. He's not going to like me for saying that, but I think that that he had made his case to us, as far as I'm concerned. And I appreciate other people have said things about their own courts, as I have done. But what I'm saying to the committee here is, and with respect to Claudia, is you heard all the evidence. You heard the evidence across the spectrum. It's not always the quantity of evidence, is the quality of evidence that comes before a committee, and on the quality of the evidence from the Lord President. I am persuaded that taking a run at, I can't run out, I'm looking at my time, I'm persuaded on the evidence that he gave to us that this is the way forward. But remembering that the courts themselves, in the instance of the Borders courts, won't close till 2015, so we'll have a big run in time to see how things measure out. So I'm sorry, John, but I was very cruel to other people, so I'll be hard on myself. I've gone over my time by 1 minute and 19 seconds. That's my bit said. I now have nobody else. So I'm now going to say to the Cabinet Secretary, you may respond. You've got 20 minutes.
Thank you, Convener. I welcome the opportunity to respond to this debate and the motions to annul the Sheriff Court Districts Amendment Order 2013 and the Justice of the Peace Court Scotland Amendment Order 2013. And I've listened with great interest to the debate this morning and indeed throughout this process, which has gone on for some time. I readily acknowledge the genuine concerns expressed by members and indeed through their constituents from across the chamber about the closure of some of the Sheriff and Justice of the Peace courts. As Lord Gill, the Lord President, as you've pointed out, of the Court of Session, our most senior judge, has said, and I quote, "Determining the future shape of Scotland's court structure is a serious responsibility. Doing so against a backdrop of significant change and in a time of severe pressure on public finances is a difficult task with few easy answers." Initially, it may be useful to reiterate what I said to the committee at the session last week about the constitutional position in relation to these proposals. The Scottish Court Service is an independent body corporate established by the Judiciary and Court Scotland Act 2008, and I know Ms Mara was not a member then, but it was passed unanimously by Parliament, and it has the effect that the Scottish Court Service is now answerable to the Lord President rather than Scottish ministers, whether Mr Gray or his colleagues at that time, rather than myself. The working of the courts is therefore an operational matter for the Scottish Court Service and, of course, for the Lord President, who has a statutory responsibility for the efficient disposal of business in each and every one of Scotland's courts, whatever tier.
I wonder if the Cabinet Secretary will take an intervention.
By all means.
I understand and recognise the accountabilities and responsibilities of the Court Service. Will the Cabinet Secretary finally accept that he is here today because he is accountable for the orders which he has laid before Parliament, and nobody else has that responsibility?
Absolutely, that's the constitutional framework. And you voted for the 2008 Act, Mr Macdonald, and I'm glad you did. It was passed unanimously. All parties supported it. That was the right thing to do, and as part of those structures, we did agree that it would be dealt with by the Justice Secretary coming to whoever or whatever political position they may have coming here. And equally, it was also agreed that it would be dealt with by the committee. That was the structure laid down, discussed, and indeed I can put on record that it was, I think, the first act, or one of the first acts passed by the Scottish Parliament. It had been on the stocks, irrespective of the outcome of the election in 2007, that I was delighted to see me returned, was going to be brought in by any administration that was turned, which is why, as I say, it was passed unanimously. And as such, though, both the Lord President and the Chief Executive of the Scottish Court Service have appeared before this committee. Not just myself coming to move the matters that I have to do as a government minister, but they've come to give their evidence, to put their position in. We've heard comment in particular from the convener, and they've given a robust defence of these proposals, and they have been challenged quite robustly by members, whether Rod Campbell and others, including no doubt yourself, Mr Macdonald. As members are aware, while the Scottish Court Service proposed the closure of certain JP and Sheriff courts, the legislation provides, however, that it's for Scottish ministers to lay the orders implementing these proposals before Parliament, which is why we're debating it, why I'm here, and in any future matters that should come about that would have to be dealt with by the Lord President and the Scottish Court Service, Ms Mara, it will be myself or any successor to me that will appear, but the decision and the proposals, the plans will all be worked out by the Scottish Court Service in terms of the design until such time as the Judiciary Act should be changed by this Parliament in that way. So, by all means.
I think this is an interesting point which the Cabinet Secretary has laboured. He's saying that he is responsible for the orders before us, but the Lord President is responsible for their content. When the Lord President made his proposals public, the Cabinet Secretary announced, I think within 2 or 3 days, that he had accepted them. Does that not rather imply that he had the option of not accepting them, and that therefore he is responsible for the content?
As Mr Gray will know, that wasn't the precise language I used, and yes, I do accept them. Yes, I could have rejected them. But this is our most senior law officer, judge rather. He's our most senior judge. He is supported by the Scottish Court Service. He is challenged to do this in the face of financial cuts. And as I say, I investigate matters, I review them, and I support them. So in deciding to lay these orders, ministers had to satisfy, not at the moment, sorry Ms Mara, ministers had to satisfy themselves that the policy they're designed to implement is justified in the circumstances. Ministers have to look across the government's portfolios to consider the wider and bigger picture. We deliberated carefully on the options presented, and the Cabinet has given its consent to the proposals. We think that the proposals strike the correct balance in the current economic climate. So these are proposals that emanate from the Lord President and the Scottish Court Service. The decisions that they're challenged to look at in terms of the Judiciary Act passed by this Parliament unanimously. The ultimate decision to bring these motions to this Parliament has been by myself. It has been considered in the round by myself and by the Cabinet colleagues to ensure that we look at that wider picture. But I have to say, having the highest regard, the utmost respect, appreciating the financial challenges and other challenges that the Lord President and those who serve under him are faced with, I fully support and accept the proposals they make. But yes, the proposals today come from me. By all means now.
Will the Cabinet Secretary accept the evidence from Lord Gill that the convener just read out, that he was pushed into making this review because of the budget that you set down for him?
Well, I'll come on to financial matters in a minute, Ms Mara, but we do live in the real world. And in the real world, I think it's a matter that we are in a time of austerity. Whether that should run on to 2020 will depend, I think, on constitutional change and the ability to direct how we can use the money that we have. But I don't know one aspect of life in Scotland, and I know you were in Canada on parliamentary business last week, but I did mention last time that even the Church of Scotland, I think, or maybe not here, perhaps at another meeting, that even the Church of Scotland in my own constituency is going from 3 churches in Portobello down to 1 because of a variety of factors and financial challenges that they have to face. There is no walk of life in Scotland that does not live under the cloud of financial challenges. And to suggest that the court service is immune and can somehow or other bask under a ray of sunshine, frankly ignores the reality of the world in which we live. Throughout this process, many members have made the case for the courts in their own constituencies. That's rightly so, and it's understandable that they should wish to express their concerns. However, it is important to remember that we're embarking on the most significant changes to the legal system in well over a century. And these proposals are part of these wider reforms which will help create a modern justice system that's fair and accessible, cost-effective and efficient, and that better meets the needs of the people of Scotland. These wider reforms include those recommended in the reviews by Lord Gill, Lord Carla and Sheriff Principal Bowen, and will ensure that cases are more effectively managed, reducing both wasted time and the number of hearings required for each case. These outcomes cannot be fully achieved unless we rationalise the estate by taking business out of courts that are underused or which duplicate provision in an area. Indeed, as Lord Gill stated in the Scottish Court Service response to the consultation, I'm confident that the proposals in this report will contribute significantly to the success of the forthcoming reforms. That is why the Scottish Government set up the Making Justice Work programme. It brings together all the key agencies and provides a strategic joined-up approach to reform, focusing on creating an efficient and effective justice system which is fair and accessible and improves the experience of users. We also face unprecedented cuts in the funding that the Scottish Government receives from Westminster, and the Scottish Court Service, as I've said, is not immune from these financial pressures, and they estimate that the proposals will save almost £1 million per annum and an estimated backlog maintenance of almost £3 million. If these recommendations are rejected, it's clear that the Court Service will need to look at alternative approaches to make savings. As Eric McQueen, the Chief Executive, told this committee last week, if the view of the Parliament is that we should continue to operate from a 19th century court estate, that's exactly what we'll do. We'll continue to invest in buildings that we think are inefficient and not well used and take to big risks with backlog maintenance, and we'll have to look hard at the headcount of the staff in the organisation to reduce costs. Yes, it is about priorities, Ms McInnes and Ms Mara. Maybe you do want to force redundancies rather than close buildings that are no longer fit for purpose. At the recent Labour Party conference, Mr Macdonald accused us of not putting our money where our mouth is in terms of helping witnesses. He listed a number of additional things he wanted to see, including an independent commissioner and case companions. He also told Victim Support Scotland last year that it's clear that too often victims and witnesses find themselves in the same room as an accused. That just shouldn't happen. What they do not say is that all of this needs to be funded from the same declining budget. We are doing more to help victims and witnesses, and as this committee knows, we've recently introduced a bill on this very topic. Mr Macdonald.
I'm grateful to the Cabinet Secretary for taking that intervention. If indeed saving sums in the way he's described is a priority for the Cabinet Secretary in making these proposals, can he tell us why he or indeed the agency has not engaged in any meaningful discussion with East Lothian Council about their offer to contribute to the running costs of Haddington Court?
I'll refer to that. They have had meaning discussions, they have a consultation, and they have entered into, as I say, these discussions to try and assist. I'll come back to that, but I think fundamentally, as I say, I think you should accept the good grace and the evidence given by Mr McQueen. You had your opportunity last week, and I do believe that both the Lord President and Mr McQueen appeared and gave a good account of themselves. One of the main reasons for these proposals is to allow the Scottish Court Service to make better use of a shrinking budget by concentrating funds on a smaller number of better equipped courts where modern facilities are provided for victims, witnesses and jurors. It is important to highlight the point that whilst these reforms will save money, as the convener has correctly quoted from the Lord President, it's not the only reason. Other factors include closing underutilised courts that can't sit unused for long periods of time, closing courts that are no longer fit for purpose. And Mr Pentland, Motherwell JP Court does not have wheelchair access. And I have to say to you, I don't think as a Cabinet Secretary I can justify a court building that can no longer in the 21st century provide wheelchair access. That may be facilities that you're prepared to tolerate. It is not a circumstance where we look to make sure that we provide for equalities that we are prepared to condone.
Mr. Pentland,
by all means.
I'm quite sure the Cabinet Secretary will be aware that prior to the District Court transferring over to the JP court system, that there was a significant amount of money spent in modernising the District Court for that very reason. Now, part of the ongoing process within the Council would be to facilitate the wheelchair access. And this is where I find that there is a real confusion in some of these things that you're saying, Cabinet Secretary. On one hand, you're talking part of your criteria is closing for not having a modern court. I believe that Motherwell is modern with that one exception, the disabled access, which I know could be dealt with at a later stage. But I think you're using that as an ideal opportunity to meet a deadline, to meet a financial cost, to meet a cost in your budget. And where you talk also about on the point of redundancies, Motherwell, if you close Motherwell JP Court, you will cause redundancies.
Well, I think there's two matters there to clarify. First of all, I think if Mr Pentland has comments to make about regarding that, they should have been put to the Lord President and indeed Mr McQueen. He has had the opportunity to do so in writing, and he can doubtless provide the committee with a copy of any correspondence that's been ongoing regarding wheelchair access, and doubtless that's a matter members can consider. Equally, he had the opportunity last week on redundancies, as Mr Pentland will know. This government and indeed the Scottish Court Service have a no compulsory redundancy policy. Not only that, he'll know that at previous meetings which he did not attend, not only was that made clear by Mr Eric McQueen, but it was also made clear by the representative of the union representing the overwhelming majority of staff. I would trust that he would accept not just the court service but the PCS union's position on that. I have mentioned before the closures down south. I don't think that we should ignore them. In 210, 93 out of 330 magistrates' court and 49 county courts closed in England and Wales. There is a Better Together campaign, but it does seem that sometimes these matters are ignored. So whilst the impetus rose from the need to save money, it is quite clear that there are good intellectual arguments, as the Lord President made clear, about why, as indeed with a single police service, we make a benefit out of a necessity. In terms of access to justice, we all see that the towns we live in, the places we work, the way we do business, the availability of transport have changed radically since Victorian times. And as Lord Gill stated, the current court system is based on a model from these times. And if we were to plan a justice system for Scotland based on a network of high courts and justice courts, it would look nothing like we have today. We need to think in new and innovative ways about the justice system in a 21st century Scotland. We need to take advantage of opportunities provided by new technology, whether video links for conducting court proceedings, raising a civil action online, or paying fines by telephone rather than travelling to court. These all, by all means.
An intervention. I don't know if you were coming to it, but I don't know if you have any comments to make about, shall we say, peripatetic justice or justice in rural Scotland?
Well, I think that was a matter referred to. I think it was touched upon last week by myself. It was touched upon by Sandra White today. I do welcome the fact that Eric McQueen has written to the Children's Serious Reporter Service to build upon the good work and good practice that I experienced as an agent in Dundee and that continues to this day in terms of referrals that are disputed from the Children's Panel. He's also made it clear that there are other areas of civil matters that was raised, I think, by Mr Pearson in terms of adults with incapacity, or it may have been somebody else. So he's prepared to look at that. So I think he's made it quite clear that in terms of criminal justice, there can be no peripatetic matters apart from when evidence is taken on commission, as I have done in a hospital bed in a criminal trial in which I participated. But in terms of other aspects, there may be matters where civil justice would be better dealt with in an environment and an atmosphere that is not a court building, and I fully support them in that, and I can give you an assurance that that's a matter I'll be happy to work with the Lord President and the Scottish Court Service to see how we can work and take that forward. Some of these matters are not with his control, because obviously children's hearing referrals ultimately will come from there and the alternative accommodation, and similarly in matters relating to other vulnerable matters, not just children but in the elderly and the world in which we live as people get older. Ms McInnes.
Intervention on that. I'm interested to know how you responded to Scotland's Commissioners for Children and Young People warning that these proposals would have a disproportionately detrimental effect on children. I mean, did that give you pause for thought? Did you call for some more evidence on that?
No, I gave it thought and I gave it consideration, and as I always do with anything from the Children's Commissioner, but equally I took on board the evidence that you heard and I received from Capability Scotland, from Consumer Focus Scotland, and indeed the information there about the good work that's being looked into in terms of how we deal with referrals from children's hearings. So these matters are weighed in the round. As I say, I did take these matters into account, as did my Cabinet colleagues. So these are all featured the future plans of the Scottish Court Service in the Making Justice Work matter, and I fully support them. I think there's three matters that I would finally just like to comment on before I conclude. Yes, there was evidence, and as I say, I take it in the round. But equally, there's evidence from the Lord President and our senior law officer. Evidence from the Crown Office and Procurator Fiscal Service who require to prosecute this. Evidence from Police Scotland who require, as I say, to have their members and staff there, and indeed also to make sure that they provide for the safety of our communities, and indeed from the Scottish Legal Aid Board. They were supportive, so it's taken in the round. There are matters, and I think fundamentally Mr Macdonald raised it, and I'll go back to the issue of concerns. Yes, we do have to make savings. I did note today that there was no mention of savings being made and all being funded through fine income. I did listen, as I said last week, with some incredulity when you appeared on a radio programme, Mr Macdonald, to say that everything could be saved by simply better recovery of fine income. As was pointed out, fine income is improving and the Scottish Court Service is doing a remarkably good job. Equally, let me finish.
Bear with me a minute, Cabinet Secretary. Can I just say, Lewis, I'm just coming to you so you can deal with that in your summing up.
Equally, as I pointed out last week, the suggestion that fine income that goes directly in the main to the UK Treasury could provide for a shortfall in the funding available to the Scottish Court Service was not just incredible, but frankly nonsensical. And it's probably for that reason that no suggestion was made. None of the Labour members have put forward any proposal for savings. I do note that Ms Mara seems to have some proposal at some stage that we should reduce the number of police officers. If that is the Labour proposal, then they should say it. Equally, I'm happy to feed back to my Cabinet colleague Keith Brown that the Liberal Democrats are suggesting the abandonment of funding for Scottish canals. That's a matter that will be considered. Equally, we do have to do all this in the backdrop of sufficient and significant financial challenges, and it is for that basis that, as I say, whilst I have concerns, as everybody has, I have to look at the budget in which the Lord President and Eric McQueen operate. And finally, I do note some concerns raised in particular by Mr Gray and indeed by Jenny Mara. But let me say this. I do think that when we're in the world of a bedroom tax being imposed, that people should perhaps take on board, especially those who come from parties that are not committed to repealing it, or indeed who actively to support it, who actually have... Well, I'll ignore Mr Gray's sedentary interjection, that should actually perhaps worry more about those who are in danger of losing their home than simply a building, important and historical though it may be. Equally, I would also have to point out that I think there is something rather perverse, if I may say so, that we have concerns being emanated, and there's understandable basis for putting forward these matters, that people should have to go to Edinburgh between the hours of 9 and 5 for court, for example, in Haddington. And yet, when vulnerable people face requiring to be dealt with by the social work department, when they require to contact the emergency duty team out of hours, not between 9 and 5, when transport is difficult and other matters face them, when it's a mother who's collapsed and a child needs foster care, when it's an elderly adult who's collapsed and their partner who may be requiring care is needed, lo and behold, in places such as East Lothian, it's contracted to Edinburgh. I think there's something frankly perverse when people should go on with some hypocrisy about the challenges that are faced when they're prepared to accept those matters routinely being responsible by, as I say, another place. Miss Mara may nod her head, but I would ask her to consider perhaps what the situation may be in some of the areas she's been referring to in the North East. So to conclude, we cannot deliver better access to justice by avoiding the need for change. It is right that we examine structures that have served us since the 19th century. It is right and correct that they should be challenged, and it's also right and I accept that it should be kept under review, as Rod Campbell has quite correctly made clear. But if we are to deliver the expectations of the 21st century that our people are entitled to accept, as the Lord President stated last week, we recognise that all change has its pros and cons, and its advantages and disadvantages. But on balance, our considered view is that this is the way forward. It's not been easy for anyone. There are challenges for all those involved, but in the financial backdrop and to achieve the best possible court system for the 21st century, hard decisions need to be made. They've been made by the Scottish Court Service, and in that I fully support them, and therefore I agree with Lord Gill and reject the motion in Mr Macdonald's name.
Right. Low key as usual, low key. Now, Lewis, I can give you more than 10 minutes, I think, in fairness.
That's very
so could I ask you to wind up the debate and indicate whether you wish to press or withdraw your motion at the end? I think I can anticipate where you're going. Thank you.
I shall indeed do that very thing, and I'm grateful, Convener, for the allowance of extra time. I wondered before we began how I might best highlight the flaws in the approach of the Cabinet Secretary to this issue, how I might illustrate his determination to drive through these cuts and closures in the face of any offers or compromises or suggestions coming from his own backbenchers, from local authorities or from opposition members in this committee. I think Mr MacAskill, in his closing peroration, if I may call it that, has probably done my job for me. Yeah. I think there could be no better example of how completely closed his mind has been throughout this whole process to any debate, discussion, a suggestion or proposal from any third party as to how to mitigate the impact of the cuts he has made in the budget of the Scottish Court Service. He has shown us very precisely a number of things. First of all, that responsibility for these cuts is his and his alone. He says that Lord Gill, somehow or another, has to stand in front of him and take some of that responsibility. But of course, he also concedes that the reason Lord Gill is in the position he is in is because the budget that Kenny MacAskill has provided to the court service has been cut and cut so dramatically. He says that he wants to find savings and to address the issue of the economics of providing a modern court service, and yet what he does is, when asked about the offer from East Lothian Council to be supportive of the local access to justice in East Lothian, what does he do? Does he welcome their enthusiasm? Does he recognise their commitment to their local community? No, all he chooses to do is to attack East Lothian Council for some other tough decisions they've had to make as a consequence of the budget that his ministerial colleagues have given to that local authority. So I think Kenny MacAskill, in many ways, makes my case. But I think it's fair to say, too, that many members around this table have made a strong and clear case. Graham Pearson, in particular, stressed the importance of justice being delivered as close as possible to where a crime was committed. Because justice is not just another commodity to be provided only where there are enough customers to make it sustainable. It is surely a matter of principle of importance to this committee that local communities, the length and breadth of Scotland, should have access to justice, and that those accused of serious offences should, where possible, be tried by a jury drawn from their local area, and should certainly stand trial as close as possible to their local community. Certainly.
Yes, I thank Lewis Macdonald for taking an intervention. When I asked you to comment previously in regards to courts being closed, you did say some courts should be closed. You haven't exactly named them, but then again, in the contribution there, you said all people should have access to justice, no matter where they come from. So you sort of contradict yourself there when you're talking about certain ones should be closed. So I would put that to you again.
I fail to recognise the contradiction which Sandra White has spotted, but I will try to help her with the matter which she raises, because I think the fundamental point which I am making and which has been made around the committee this morning, is that when the government seeks to impose cuts on a public service that affects local communities, then it should seek to do so in meaningful consultation with those local communities and with the local representatives who speak for those local communities. And if it did so, it would find, as I mentioned in the case of Highland, that those local representatives would distinguish between cuts which would and cuts which would not have a significant impact on the quality of access to local justice.
Would the member take an intervention on that?
In just a moment. The point about the local delivery of justice and justice being seen to be done in local communities has been tacitly accepted by the government in many of our island communities, although not those island communities in Argyll and Bute. But under these proposals, that local access to justice will come to an end across large parts of the Scottish mainland.
Thank you. I'm grateful for the member taking an intervention. I wonder if the member would reflect on Highland Council's position with regard to Dornoch Sheriff Court, both with regard to the workload and its close proximity to Tain, and what his view is of that.
Well, I accept that Highland Council are far better placed to make those judgments than I am. And I recognise, as I said in my opening remarks, that actually Highland Council have not said all these closures are wrong, all these closures should be resisted. They have recognised that some courts are better fitted to deliver some services than others. That approach was open to negotiation and discussion, but negotiation and discussion of a meaningful sort has simply not occurred. And Mr MacAskill said he would come back to the question of the discussions with East Lothian. It seems to me, from everything we have heard, that the discussions with East Lothian were an offer from the local authority to assist in access to local justice, and a refusal by the Scottish Government to have anything to do with that proposal whatsoever. That does not seem to me to indicate an approach which seeks to build local support, or seeks indeed to negotiate, to recognise that some closures are going to be more damaging than others. And we have heard nothing today from the Cabinet Secretary to respond to the points that have been made today and previously about the impact on busy city courts of closing courts in our county towns. And indeed, I can tell Roddy Campbell that the performance figures he could not find for city courts are available in the performance reports of criminal justice boards. And Jenny Mara has reminded me that the figures for Dundee last September show that, like Edinburgh and Aberdeen, Dundee also fell short of its government targets at that time at 78%. Because we have seen written evidence from serving and from past sheriffs about inadequate facilities at those city courts, and we have heard the concerns expressed by local lawyers and others who engage with the system about further delays in the delivery of justice. And if justice must be seen to be done, it is also true that justice delayed is justice denied. And to talk, as Eric McQueen did last week, about Aberdeen Sheriff Court being able to operate at 97% of capacity is again to treat court cases as if they were all uniform commodities which can be standardised to fit into the relevant slot, when of course the reality is that they are all different and enormously difficult to schedule effectively and efficiently, even at the best of times. Court cases are delayed or postponed or continued on a daily basis. The busier a court is, the less room there is to accommodate those changes, and the greater the knock-on effect. So glib assurances that all will be well are simply not enough. Many of our busier courts are struggling now, and they will find it all the harder to cope as extra business is sent their way. The greatest opposition to government's plans has, of course, come from those towns across Scotland which will lose their local court. And the committee has heard from many hundreds of people in those communities, from detailed analysis by a forensic accountant in the case of Haddington, to the petition collected from hundreds of visitors to the Fian Market at Stonehaven just 10 days ago. I have asked the Cabinet Secretary several times to explain how the wider impact of proposed court closures had been assessed, whether by him or by the Scottish Court Service. And last week he assured me that such an assessment had not only been made but had also been published. Unfortunately, it turns out, as I feared, that he was talking about the single page of the regulatory impact assessment which appears under the heading of Scottish Firms Impact Test. That says, among other things, the closure of sheriff courts in close proximity to another is likely to have the greatest impact on the local economy. This reduction in activity should be offset by increased activity in the location to which activity is relocated, and alternative uses for the court buildings are likely to be found over time. So that is the assessment of economic impact. Don't worry, in a moment, don't worry, because Mr because Stonehaven's loss will be offset by Aberdeen's gain. Don't worry, because your local courthouse will make splendid flats for people commuting to work somewhere else once your local court has closed down. Mr Fleming.
I'm grateful for the member allowing intervention. I have a 10-page business and regulatory impact assessment. I wonder if the member is familiar with that and the detail it goes into.
I have looked at it from top to toe, Mr Finney. I was encouraged by Mr MacAskill to do so. I fear in those 10 pages there was only one that made any effort to address economic impact, and I think I've quoted the best bits of it. I won't quote the worst bits. But I perhaps will mention only one other. According to the government's assessment, it is considered that while there may be some economic impact, and this is talking about local solicitors, which the convener will be very familiar with, firms are unlikely to concentrate solely on court work and will have diversified into various other areas of law. Of course, solicitors in small town do not concentrate solely on court work. But as an assessment of impact, that sentence is breathtaking in its complacency. It advances no evidence, offers no sources, and is clearly not based on engagement with any of the firms in question, contrary to the normal standards, even of government RIAs. Members should instead pay heed to the considered views of solicitors who work in towns like Stonehaven and who draw attention to the combined impact of cuts to legal aid and court closures on court clients and on solicitors. Certainly.
You did hear me say that the people's solicitors do support me, so that it is not the case blanket that local solicitors are opposed to these changes.
It's precisely the point I made in response to Sandra White and also to John Finney. There is not a blanket response to these changes. There is, however, a blanket failure on the part of government to negotiate or discuss with any of those who have raised such objections. And it would be no surprise if members had heard, as I think they have from many witnesses, about concerns about the impact on removal of courts on the civic pride and identity of our county towns. And people who have voted for Mr MacAskill's party may have been forgiven for assuming that the SNP's attachment to the civic pride and identity of county towns was a given. These things are rooted in Scotland's history, both before and since the Act of Union. Scotland's courts, indeed, are one of the 3 areas of national life protected for all time coming under the Treaty of Union with England. It must come as a shock to many to have heard an SNP minister last week talk of local courts as a relic of a barbarous past, on a par with hanging and with public humiliation. It will be even more of a shock to recognise that locally elected members of that party may choose to put obedience to the dictates of their party whips ahead of the interests of their local towns. Mr. Tier. Certainly. Certainly.
Thank you. It's your reference to what the Cabinet Secretary said. What about the reference that, or can I ask the member about the reference that the Lord President made about the state of the courts and the fact it was from a bygone era and didn't suit the 21st century?
The Lord President also said the technology exists to have a system that is based entirely on remote access to courts. He quickly added that he was not proposing that that should happen, but equally it is true that the proposals before us do not address all the inadequacies of our existing courts. They address some of the inadequacies of some courts by simply closing them down and do nothing at all to address the inadequacies of others. But, Convener, if I may conclude with some comments about the issue, I think a central issue, of democratic accountability. I was surprised to hear Kenny MacAskill, even today, continue to maintain that his court closure proposals were not really his proposals at all. In 14 years of the Scottish Parliament, I can recall no other instance of a government minister laying statutory instruments and pressing his party colleagues to support them, while simultaneously claiming to be a mere cipher for the wishes of somebody else. The reality is that these are proposals, are orders and statute. They are the sole responsibility of Mr MacAskill, and it is he and not anybody else who is accountable for the content of those proposals to Parliament. But responsibility for determining Mr MacAskill's proposals lies with each and every member of this committee. It does not lie with SNP whips. It does not lie with SNP ministers. It lies with those members of this committee who choose to vote for the closure of local courts. Lord Gill, of course, is a big figure in the Scottish court system, but he is not big enough even for the Cabinet Secretary to hide behind, and he certainly cannot be used to disguise the responsibility of members of this committee to make a decision both on behalf of their constituents and on behalf of the people of Scotland as a whole, and to live with the consequences of that decision. That is what MSPs are elected to do. Members' reservations or extended video links will not compensate for the closure of local courts, and it is on that basis that I will press these motions to a vote today.
Thank you very much, Lewis. I'm now going to put the question on the first motion because the separate questions on it. The question is that motion, and it's only members of the committee that can vote, of course. The question is that motion S4M 06648, that Sheriff Court Districts Amendment Order 2013 brackets SSI 2013/152 be annulled, be agreed to. Are we all agreed?
Yes.
Yes. No. There's not agreement, so there will be division. Those in favour, please raise your hands. Those against, please raise your hands. There are no abstentions, as I can see, so that motion is disagreed to. The second motion, the question is that motion S4M 06649, that the Justice of the Peace Court Scotland Amendment Order 2013, SSI 2013/153 be annulled, be agreed to. Are we all agreed?
Yes.
Yes. We're not agreed, there will now be a division. Those in favour, please raise your hands. Those against, please raise your hands. There are no abstentions. That motion is not agreed to, and accordingly that concludes parliamentary consideration of these instruments. Now, committee, can I first of all thank everybody for the manner in which the debate was conducted. It's a very difficult issue and a lot of people, a lot of feelings, and thank you very much for your courteous behaviour to each other. Now, we are required to report on these instruments. Can I suggest we keep this as brief as the points have been raised in detail on the record, so they'll be available in the official report, but I'm in your hands about that. I would therefore suggest the report just sets out the details of the committee's inquiry, when we met, who we heard from, and the results of division, and not go into the detail of the debate, because there's been extensive debate today. That's up to you. If you're happy with this approach, or do you want, I could delegate, just sign it off, almost like a minuted thing, but if you want a further report, that's up to you.
Content with the first.
Content with the first. Thank you very much. Thank you. The next meeting is on the 18th June. It's at 10 o'clock. We'll take evidence of the fire provisions of the Police and Fire Reform Scotland Act, consider correspondence on the offensive behaviour at football and Threatening Communications Act, consider the government's response to a report on purposeful activity in prison, and, delight of delights, consider our work programme, in which I think more legislation is coming down the track. I now close the meeting. Thank you very much.